What is the mistake?
Page number 2, 3, and 5.
What is the mistake?
Mistake means DI of Jalpaiguri Institute, Alipurduar.
Alipurduar. Mentioning the words words in para 6 at page 3 in 1, 2, 3, 4.
Page 2 also.
Fifth line. Any other place?
Page 2, page 3, and page 5. I have
Page 2.
page 2.
Page 2, which place? Oh. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 12, 14th line.
Page 3.
Page 3. Done.
2 portion.
1, 2, 3, 4. Fifth line. After in para 6. Then in which place?
And page 5.
Page 5, paragraph 12. Mentioning the words District Inspector of Schools AC, Jalpaiguri. Respond number 5 instead of District Inspector of Schools AC, Alipurduar. The words District Inspector of Schools AC, Alipurduar be read in place of District Inspector of Schools AC, Jalpaiguri. In the aforesaid places, we will mention further. The other portions will be modified.
Your Lordship.
I think 3.
Yeah.
Millard, the petition Millard was dismissed for non-appearance. Millard, today it's under the heading application Millard for restoration of the petition Millard. There is a delay of 104 days.
104 days.
Yes, Millard.
What is the
Millard, the answering respondent is the Jila Parishad. Millard, we have served, it is delivered. But para 4 and 5 of the recalling application is Millard the reasons.
who appears for Jila Parishad?
Generally, Millard, there is
State.
No, not state. State does not represent the Jila Parishad. Otherwise, Millard, I could have served on Mr.
Executive officer is the district magistrate.
Yes, but Millard, it is generally represented by a separate set of councils. If Millard desires, I can serve a copy on Mr. Bhattacharya. Millard, no difficulty. He can take instructions.
Mr. Saha appeared for whom? Mr. Arnav Sir, respond number 3, 1 to 3.
The earlier occasion, probably Mr. Shaha had appeared for the Jila Parishad.
Yes. Serve afresh or give a notice to Mr. Saha if he has appeared.
Right, we can do that.
Affidavit of service filed on behalf of the petitioner is taken on record. This is an application seeking for restoration of the writ petition upon recalling of order of dismissal dated 12th August 2025. None appears. On behalf of the respondent, Jalpaiguri. On the prayer of learned advocate for the petitioner, let service be effected upon. There was a contempt. Mr. Ghosh,
Millard?
there was a contempt.
Yes, Millard, there was a contempt.
Service be effected upon the Jalpaiguri as well as its learned advocate on record. The service has been effected in 19 January 2026. For such reason, reference. Release this matter before the next available circuit. Effect service upon the Jalpaiguri as well as the learned advocate.
Yes, yes. We will.
I can vote.
May it please.
For my lord, I appear for the state, led by Mr.
Now, the point in this matter is, my lord, it's very simple and, my lord, absolutely legal. My lord will kindly turn to page 107. A purported notice is issued by
Just 107. Yes.
now this is supposedly, my lord, for extension of NHIA, National Highway. And the National Highway Act is there, which is special statute for the purpose of taking action.
Yes.
Now, my lord will kindly turn to page 42, that we had applied before the authorities to get the information whether any action under NHIA was at all taken. Page 42, my lord, is my query to the RTI authority. Lord, you will kindly see, my lord, the query which was made. Kindly provide me the details along with the information under RTI Act as per section 6(3) of the RTI Act, in case the requested information is held by another public authority, but information was sought whether action was taken under section 3A and 3C of the National Highway Act. The answer was very curious. Look, the next page, the
Where is
answer, and page 43. This is to inform you that the required information is not readily available now. Further extensive search is going on for the same and will provide it if found. But unless the action will not is complete, if at all, under the National Highway Act, that the subsequent notice is without jurisdiction. Kindly takes up
So
the
you are
National
carrying the-
Highway Act, Section 3.
Yes, so you have the National Highways Act. National Highways Act, you can.
National Highways Act এর অশোককে দাও।
দেখুন ওখানে আছে।
Has well got it.
No, your junior is not carrying the act. We are finding out from the
Oh.
court whether it is. একটা কাজ করুন আমার ল্যাপটপটা নিয়ে আসুন।
একটা নিয়ে কোর্টে যাওনি কি গো?
Sir. Mr. Bhattacharya, you are having the act.
I had pilot now by I'm
Lordship, I appear for the National Highway Authority in this matter.
Yes, we'll come to you.
Lordship.
Let Mr. Bhattacharya complete his submission.
Kindly have a lordship got the act?
No,
Oh,
yes,
oh.
Mr. Bhattacharya.
Kindly come to section 3.
Yes, 3.
Then
3C.
Milord, 3A, first power to acquire land, etc. Where the central government is satisfied that for a public purpose any land is required
Yes.
for the building, maintenance, management or operation of national highway, then Milord, the subsequent steps to be followed. It empowers Milord
Yes.
them to take possession, inspection, everything, then hearing of objection, then declaration of acquisition. Then Milord, the
Yes.
question comes E3E power to take possession. Therefore, this particular special statute empowers NHIA to take all these actions, which not having been taken, can they proceed any further under the garb of NHIA? But this is the simple thing, Milord, which requires for consideration.
Now, what is 107 then?
And yes, 107 is supposedly notice under the West Bengal Act, taking that NHIA requires, kindly come to the language is very funny. এতর দ্বারা জানা যাইতেছে যে পশ্চিমবঙ্গের অংশের থানা মৌজার অন্তর্গত এভরিথিং জাতীয় সড়ক 31D 113.20 থেকে 154.84 কিলোমিটার সরকারি জমি পুনর্বাসন ও উন্নতিকরণ প্রকল্পে অনুমোদিতভাবে দখলদারির জন্য আপনাকে যে বিজ্ঞপ্তি জারি করা হয়েছিল তার যথাযথ কোনো উত্তর আমরা এখন পাইনি। এছাড়া আপনার সপক্ষে কোন রকম বৈধ কাগজও প্রদর্শন করতে পারেননি। Who are they? Then Milord, National Highway Act itself empowers the National Highway Authority after completion of proceedings to take possession. How come Milord, the state authority issue this notice? This is Milord,
So there is no such authority of the state to acquire and then hand it over to National Highways. National
No.
Highways under the act can itself
Yes.
initiate such proceedings.
yes. And that's why when we wanted to get the information, they say we don't have any record. We are searching out.
Okay. And what is 3C? Object to the land.
This is Milord, objection should be heard. Then Milord, they will have to come to a conclusion. That conclusion must be based on reason and then declare. Nothing has been done. How could they now proceed to grab my land and block my Milord entry by dumping different materials to prevent my access to my shop rooms?
With the leave of my learned senior, also pointing out that they have already dumped materials in front of my shop and materials, which is a part of the highway.
Lordship, Lordship is not audible.
But the court is not audible.
Your Lordship is probably muted. Your Lordship, we are not able to hear your Lordship.
The court is not audible. Lord, we could not, Lord, hear your Lordship. Lord, the court is not audible. কি হলো বোঝা গেল না।
And I was speaking about on the previous occasion. There's a policy of, my lord, the Shiliguri Municipal Corporation. Please come to page 34. This is what we are requesting, Lord.
Lordship, we were not able to hear what happened in the previous matter.
Yes, can you hear me?
Now your
Yes, now
Lordship
we
is
can.
audible.
I have fixed it on 11:30. So if you kindly join on 11:30, at 11:30 we'll proceed. Mr.
Right.
Bhattacharya at 11:30.
Right.
Okay.
Ground first and second 3 floors. The
No, you're referring to which page number?
page 34, my lord, annexure C of the canon. This is a policy decision of the Shiliguri Municipal Corporation. Pursuant to the resolution adopted in the Mayor in Council meeting dated 11 November 2025 and subsequently endorsed in the Board of Councillors meeting dated 29 November 2025, it is hereby ordered that in accordance with the provisions of Section 290 of the West Bengal Municipal Corporation Act 2006, the following is notified for public information. The Shiliguri Municipal Corporation has resolved to allow the installation of lifts and or the construction of additional staircase in existing buildings within its jurisdiction, subject to the conditions detailed below. The applicant must submit a detailed drawing of the proposed lift or staircase, must submit a structural stability certificate issued by an empaneled structural engineer, prescribed fees for processing such permissions shall be as follows: rate chart provided. This provision has been introduced to enhance accessibility, particularly for senior citizens and persons with mobility impairments, and to improve circulation and safety in existing buildings. Now, my lord, my store has been functioning from 2016. I had an internal connecting staircase made of RCC and a pneumatic baby lift through which intra-floor mobility was possible. This was done without any prior sanction because we were advised. We are Manyavar and Mohe. We have 700 outlets in the country. We are legally compliant. We never do anything without taking permission. But we were advised that because these are internal structures, there's no necessity for a sanctioned building plan. Therefore, we went ahead on that advice when we commissioned our store in the mall in the year 2016. 10 years later, pursuant to the complaint of one of the shop owners, a demolition drive was undertaken in the entire mall. About 30 items were identified, all of which, excepting ours, were external deviations. Our two were internal, but en masse an order of demolition was passed by the commissioner. Challenging that order, and because we don't have a tribunal here, challenging that order, we went up in writ petition. Your lordships were pleased to protect us. Thereafter, my lord, a number of petitions and writ petitions arose. In one of the writ petitions, during the pendency of the writ petitions, this policy was announced. When this policy was announced, we applied under the policy, and the Siliguri Municipal Corporation granted us permission to install after taking fees. But perhaps that installation was already there. So that permission to install which they had granted was technically beyond the scope of the policy.
But it was post facto.
It was post facto. It could have been done. But when the matter came up before an honorable single judge, Justice Kapoor, the corporation took the plea that because there's an earlier order of demolition, we should not have granted the permission, and therefore we retract the permission. That was noticed by his lordship, and his lordship directed that therefore go ahead and demolish. That was an interim order. Against that interim order, we carried appeals to the division bench. The division bench said that this retraction gives you a fresh cause of action. Please file a new writ. So this peanuts retail writ, which has come up before your lordship, the mother writ of the can, is an outcome of that liberty given by the division bench. When this matter came up before your lordships in the previous circuit, an honorable single judge was taking up the matter. We sought leave to file a supplementary affidavit, bringing on record the fact that in the meantime, the retraction had taken place and other incidents. Liberty was granted to us. Matter was made returnable in the next circuit. Corporation appeared. They didn't ever say that they were going ahead with demolition. Be that as it may, there was no interim order passed. I should be candid. Before the matter could appear in this circuit, previously, I think last Saturday, a posse of people went from the corporation, pulled down the internal staircase, RCC internal staircase were demolished, and the pneumatic baby lift was also dismantled and demolished. We tried to resist them, but they said that they had superior instructions. Now, there's a legal point still involved that whether they could have done that, even if they have done that, whether an action of the defendants in a suit can make the plaintiff's cause of action infructuous. It can't, because lis pendens will govern. If I win in the end, they'll have to restore it. But that's a question of law. Sometimes practicality gets the better of law. We are taking a pragmatic stand. We are saying, without going into the question of whether we at all required reconstructional sanction for those lift and staircase, fact remains we didn't take any, and they pulled it down. So let bygones be bygones. We are not pressing that issue further if we can. Instead, we are going up to them now that we have cleansed ourselves, allegedly purged ourselves, even that, assuming that was necessary. We are ready to file now an application under this policy, which I have shown your lordship. So there is today no RCC staircase, no pneumatic baby lift. For the first time as an applicant, instead of post facto, we are seeking pre-constructional, pre-installational sanction. We'll make that prayer before the municipality. They'll go, they'll inspect the place, and they'll suggest a suitable place. Best place would be the one where the thing was already there. But I cannot, my lord, really impose that on the municipality. So today, let the municipality go. In the presence of my men, they will hold an inspection, and then they'll permit, because the policy says that they should permit. let them permit, we'll install it back again in the manner as they deem fit, with all appropriate clearances. So this is not my can. First prayer. Second prayer is, in the meantime, we are in trouble. Last Saturday, because there's now no intra-store mobility. Not only are customers going up, because these are 3 floors, ground, first, second. Not only are customers going up, but sometimes the materials have to be taken down by us, our men, from the upper floors to the lower floors and vice versa. Now, if we are not allowed intra-floor mobility in the meantime, then every time if we come outside our store, use the main escalator of the mall, that cannot be done, because the escalator of the mall, which serves the main mall as a common area, cannot be used by any person for moving main materials or utilities. So our business will come to a grinding halt. As a result of this, and just by way of a temporary measure, my lord, we have put in place a wooden structure without operationalizing it. The wooden structure looks something like this. I'll show you, lordship, because there was one concern in your lordship's mind and my mind as well. Is it just a mowing or is it just like a ladder, so that if anyone accesses it and falls down, then there'll be a problem? So, my lord, the wooden structure looks like this. I should be candid to your lordship. There is no question of any stability aspect here. It's being well looked after. Now, in all malls all over India, if not the world, all internal floors are connected by structures of this nature. We had made it RCC. That means we had made it by cast concrete. Now, this is, my lord, a structure, which is, my lord, a plywood structure, but concrete, robust plywood structure. This has enough, my lord, wherewithal to easily accommodate the weight of persons going up and down. We don't intend to keep this as a permanent feature. This is just for the purpose of makeshift operation of our store. Otherwise, our business will come to a halt. We are putting in our application. I've instructed, Lord, I've advised, and I'm instructed also that the application will be put in course of today. We wanted to put it in yesterday, but it was too late. And now, my lord, the office will opens at around 11, I'm told. So we are putting it in the course of the day. Let the municipal corporation go and visit, and let this thing be resolved in terms of the policy. In the meantime,
Yes, continue.
yes, in the meantime, my lord, the internal woodwork, this wooden structure, staircase, I should be allowed to operate that without prejudice to the rights and contentions. And the fact that this has been put in place should not prejudice my application before the corporation. That's my prayer.
Since you are filing an application, let me find out from them how long they will take to
Yes,
have this permanent one,
yes, yes,
not the
permanent.
prayer B,
Yes.
first one.
Yes,
How
yes.
long they will take, sir?
My lord, I'm appearing on behalf of the Jalpaiguri Municipal Corporation, my lord. My lord, my learned senior has referred to the notification dated 19/12 to 2025. My lord, he has stated that in lieu of that notification, we can consider their proposal and accordingly we can grant permission. My learned senior has also stated that on June 6th, 2026, the demolition drive took place. My lord, no one has stopped him till date from filing the said application. So this is an application which he ought, if there was such a requirement, he ought to have filed on June 7th itself. Because after cleansing himself of all the wrong illegal construction, no one had stopped him. So he could have. For that, no application was required. No one had stopped him. Secondly, my lord, in the notification dated 19th of December 2025, your lordship will find that there are 3 clauses. Clause number 1, clause number 2, and clause number 3. My lord, let him make an application in according to these clauses. There will be a BOC meeting, my lord. These applications are approved by the BOC meeting. My lord, in that BOC meeting, this application will be taken into consideration. And if it is within the purview of the law, then it will be allowed, my lord. Now, my lord, in regard to the second prayer, which my learned senior has made, that after June 6, 2026, they were compelled to make a structure. First, it was a temporary structure, but now what I have heard, I haven't seen because that picture has not been annexed. But what my learned senior has stated to your lordship, it can be found that it's a PVC concrete structure where a ladder has been. Right. It's a PVC concrete structure. My lord, so that structure itself, without the permission, subject to correction, my lord, itself is wrong. So let them make an application that will be considered by the BOC. If that application is within the purview of the statute, it will be allowed.
What is the time frame for considering that?
My lord, to be very honest, being an officer of the court, my lord, post-election results, my lord, your lordship is aware that it will take some time, maybe 4 weeks, my lord.
4 weeks. Make it within a period of 10 days or.
My lord, BOC meetings are held every month, once every month.
So we are in the first half of this month.
Yes, so maybe,
When is the next BOC meeting?
maybe
The month of July.
July.
Because
No,
there's
no,
some
you
matter
conduct
before the BOC, just to be placed before the MIC.
Hmm.
Today we are on 16th.
16th,
Already the
MIC has
agenda-
complete.
The agenda to be placed in the MIC is already over.
Over.
Lordship, they can wait at least 1 month.
At least if your lordship gives a direction to that extent, that as a special case, it will be considered, then the time.
Because he's before the court, he is intending to file an application only because there is a internal arrangement of the BOC to be
My lord,
once in a month.
once in a
He should
month.
not suffer for that. If he files an application, then you keep it pending for the next, when the BOC will meet.
The next BOC is supposed to be held on July, in the month of
Make a
July.
urgent-
Today is
urgent
June
meeting.
16th.
Within a period of 15 days, you dispose of his application.
My lord, kindly make this direction to that.
It is also required, you make your inspection. I'm not passing any order with respect to A. You conclude within 15 days. His fate of his application. Make an inspection.
Make an inspection.
Inspection as to where the.
Before the BOC meeting, I suppose the municipality has to hold a place where
Yes,
the
yes,
installation is to be made.
But my lord, the notification dated 19/12/2025 does not state that any inspection is required, my lord. It only provides 3 clauses. The applicant must submit a detailed drawing of the proposed lift or staircase.
So you don't cause any inspection and allow the structure to be installed at a place as intended by the petitioner. That I can,
My lord, first
you don't require any inspection for that.
my lord,
Whatever they say, they will install over the place.
very well, my lord, then we will make an inspection with our engineers
Even
in
if
the
it is
presence
not
of
in
the.
order. It says an applicant must submit a detailed drawing of the proposed lift or staircase. Now, it may so occasion that what he has given the drawing, that is incorrect.
Might be.
So feasibility of particular staircase is to be assessed by the,
Deeply obliged, my lord.
you
How-
file your application by today, after filing 15 days, they will dispose it off.
Yes, and Lord, regarding that makeshifting, in the meantime, Lord, otherwise my store will stop, my Lord. A store will
Makeshift
come to
then-
it. The makeshift one, I take guarantee, my Lord, for
No,
the
no.
stability. The difficulty, my Lord, is otherwise my store will come to a
No,
grinding halt.
not prior B, they will expedite and do it
Hmm.
within 15 days
Then,
from submission of the application.
in that case, Lord, kindly keep the can pen. Your Lordship keeps the can pending, then we can come back to your Lordship. In the event we don't.
আসুন। Can 1 of 2026. This is an application. Your affidavit of service?
Yes. On before the awards.
Seeking, filed by the petitioner seeking leave to petition number 1 to submit a written application before the Siliguri Municipal Corporation for approval and or permission to install internal connecting staircase and internal connecting pneumatic baby lift at an appropriate place within the store. And further allow the petitioner to make a
But this-
makeshift arrangement of
The second
temporary.
prayer, I am not pressing for the time being, otherwise a refusal would mean, my lord. Second prayer, I'm,
Okay.
Lordship may consider I'm not pressing for the timing, kindly keeps the can pending.
The applicant is a company. No, second organ. The applicant is a company within the meaning of Companies Act 2013, having its registered office at Square 1, Shantiniketan complex, such and such, and is operating under the name and style of M&M Store. Comprising of contiguous units on the ground floor, first floor, second floors being numbers এখানে পেয়ে যাবেন at Planet Mall, Sevok Road, Siliguri. As the franchisee of the exclusive brand outlet of Myanmar Mohe, brands of Vedant Fashions Limited, who are the lessees of the said store. The Planet Mall is comprised within a huge land area of 149 katas, 13 chitas, 35 square feet, under the jurisdiction of Bhaktinagar Police Station. The said mall is running since 2016.
2016.
2016.
16 তো কবে বল
Of late, the internal connecting staircase and internal connecting pneumatic baby lift has been demolished by the Siliguri Municipal Corporation respondent number such and such on 6 June 2026. Which has led to filing of the present writ petition, present application. Mr. Arindam Banerjee, learned senior advocate, appearing on behalf of the applicant, at the outset submits that he is not pressing the prayer B as of now. Stop. He submits that the petitioner intends to submit an application in terms of order of the municipal corporation, Siliguri Municipal Corporation, dated 19 December 2025, seeking for permission to install proposed lift slash or staircase as required under such order. Due to dismantling of the internal staircase and the pneumatic baby lift, the business of the petitioner is hampered. He seeks for a early resolution of the issue by the Siliguri Municipal Corporation, so that the business of the petitioner is carried on without any hitch. He also submits that such internal connecting staircase and the pneumatic baby lift can be installed in the place where it was, or as would be suggested by the Siliguri Municipal Corporation. Para. Mr. Swanso, learned advocate, appearing for Siliguri Municipal Corporation, submits that the submits that the BOC meeting takes place once in a month. However, if the court directs, the application of the petitioner seeking permission for installation of the lift and staircase and pneumatic baby lift can be expeditiously considered. In view of the submissions advanced, leave is granted to the petitioner to submit application seeking for installation of interconnected staircase and pneumatic lift. Stop. The Siliguri Municipal Corporation, upon submission of such applications, had consider the same in accordance with law as expeditiously as possible, preferably within a period of 15 days from date of submission of the application.
My lord, one since before your lordship, subject to correction. 15 days will be July 1st, 2nd. Can it be 3 weeks, my lord? Then at least we'll get 1 week in the month of July. Because 15 days, 16th, my lord. 15 days will be July 1st. If your lordship may.
I'm severely suffering. I'm requesting my learned friends. I'm requesting kindly the
We
question of my
started
bread
with
and butter.
4. I make it 2 weeks because of the business being hampered. The goods cannot be.
I'm severely suffering. I'm
It is
requesting
not
my
on the
learned.
date that in the first week of July you will having, because
It
you
may
are
be in the
intending
middle
to
of
put it
July.
as if the BOC will
Happen on 1st July.
happen on 1st, and so first week of.
Just 1 week, if your lordship.
So I'm
No,
requesting
you-
my learned friends. I'm requesting my learned friends. This I'm requesting.
You file your application, Ajan. Application. List the application before the next available circuit bench.
সবে তো জজ সাহেব লিভ নিয়ে তুই জবে জমা দিবি তবে My lord, may I only again at the risk of being reprimanded make a prayer. Ordinarily the word preferably your lordships use, I would never stand in the way. Here if your lordship sees
Preferably কথাটা কেটে দিন within a period of 15 days.
deeply blessed.
11:30.
Lord, item number 32. Item number 32 was a writ petition, is a writ petition by Vedant, the lessees, challenging the self-same action. So now let this stand over and appear along with this scan. Item 32 of your lordship's list.
In the afternoon, when the 32 will be called on, you
Yes.
ask your jury to remain present.
Someone will inform your lordship. I am deeply obliged. Obliged.
11:30 item done.
My lord, I am for the state.
For the National Highway Authority.
Yes. Mr. Das, now can you hear me?
Yes, Your Lordship.
Yes. What is your submission with regard to the submissions advanced on behalf of the petitioner?
Lordship, insofar as the land is concerned on which the petitioner's shop room is situated, this land was never acquired by the National Highway Authority of India. In fact, this particular shop room is situated on a land belonging to the state government, belonging to the Public Works Department of the state of West Bengal. The petitioner is an illegal occupier of the land. He is an encroacher. He has absolutely no right, title, or interest in respect of such property. Your Lordship, insofar as this land is
Okay.
concerned, it was obtained by National Highway Authority from the state government. My learned friend who is appearing for the state, he may also produce relevant information with respect to the nature and character of this land, because this land belonged to the PWD. There was no
PWD.
compensation payable for this land. Yes, Your Lordship. This is PWD land.
Then in both way, the notice which has been given dated 15 September 2022, if this, you say it is encroachment, then West Bengal Highways or any other encroacher may be removed in accordance with law. So what was the purpose of issuing a notice for acquisition?
Lordship, insofar as this particular land is concerned, Your Lordship, there was no question of acquisition at all, because this land was
Okay.
provided by the state of West Bengal to the National Highway Authority.
Okay. Yes, Mr.
Yes,
Bhattacharya.
Whatever preliminary instruction I have, my lord, is that the land was provided by the state government to national highways.
Hmm.
And my lord, thereafter, this was for the purpose of construction of 4-lane highway, my lord. And on the request of national highway thereafter, my lord, the issues under notices under the West Bengal Public Land Eviction of Unauthorized Document Act has been passed. Now, after the notices were passed under section 3(1), which my lord calls for hearing.
Yes.
3(1), my lord, is a notice, which is a notice for hearing, my lord. If I may please the section, my lord. The notice at page 48, my lord, one of the notices at page 48.
So impugn notice is
One of the impugn notices is at page 48. If your lordship kindly comes to the prayer at page 14, now declaration that the impugn notices and advertisement dated 5th August 2022. Now page 48 is 5th August 22. Thereafter, my lord, 22nd August 22, 5th September. A series of notices, my lord. So my instruction as of now is that after these notices of hearing were issued, then my lord, the order, since the occupants there, this is admittedly a PWD land, my lord, government land. And after the notices were issued, my lord, these the occupiers there, my lord, could not produce any document, my lord, to establish the ownership of the land. So thereafter, my lord, time was given to them to vacate the property, which they did not. And my lord, order of eviction under section 4A1 was passed.
where is that?
That order is not part of the writ petition, my lord. I'm asked for them. But against that order, my lord, an appeal was filed. That appeal, my lord, is at page 53. But appeal under section 7 of this act, the said act of 1962, at page 53.
Yes.
This matter. So this appeal, my lord, I will not make any submission on the status of the appeal because I do not have any instruction on that. But having said that, my lord, on the last occasion, prayer was made in respect of Can 1 for an order of status quo, my lord. And there also, my lord, if your lordship kindly remember that I had objected to that prayer of status quo, saying that this is a project, infrastructure project, my lord. And infrastructure projects, my lord, knows that injunctions are usually not given until and unless, my lord, an absolutely illegality is shown, my lord, which here it is clear from the entire writ petition, my lord, they are occupiers. And my lord, proceedings have started under this act by the state government to evict them. Having said that, my lord, today we will be praying for affidavits to be filed, my lord, but in the meantime, my lord will kindly vacate the status quo. I am, my lord, today relying on Section 41 HA of the Specific Relief Act. My lord knows that injunction when refused, if it would impede or delay the progress of compensation of any infrastructure project or interfere with the continued provision of relevant facility related thereto or services being the subject matter of the project. Now, this is one, my lord. Second, lordship. Yes. There are two orders, one order and one judgment, my lord, I'll be relying on. Now, this lordship, I am relying on this section and the two judgments only so that the order of status quo which was granted by your lordship may kindly be vacated pending final adjudication of the writ petition, my lord. Since this is a project of national importance.
Yes.
One order, my lord, this is passed by the Honorable Division Bench of my lord Justice Vishwanath Samadar, as his lordship then was, and Justice Arindam Mukherjee. This I have been informed, my lord, is still pending. Now, my lord will kindly excuse me for handing over the printed copy from India Kanun. I could not get it from my website, from the website of this. My lord, this is in respect of WP 26137W of 2018. This is in the case of Devesh Shah versus Union of India. This is an order dated 20th of September 2019. Now, here, my lord, what has happened that is a small order, my lord. I'll just place it, my lord. Let the report filed in court today on behalf of the District Magistrate Murshidabad, signed on 17th September 2019, be taken on record. This report indicates removal of encroachment and structures from the Besu Devkhali Moja area under Police Station Behrampur, Sadhukhali, and such and such Moja area under Police Station Rajinagar, District Murshidabad. This is also with respect to construction of National Highway. Let the fifth interim report filed in court today by the learned special officer be also taken on record. Perusing the said report, it appears that he has annexed a record of discussion of a meeting regarding the widening project being carried out by NHAI, which was held on 12th February 2019 in the office chamber of the Land Reforms Commissioner, Government of West Bengal. Taking into consideration the record of discussion, we are of the view that the Divisional Commissioner Malda Division may be directed to take up the pending arbitration cases and dispose of the same as expeditiously as possible, preferably within a period of 2 months from date, but not later than 31st December 2019, so that all pending arbitration cases are resolved and the widening project of the National Highway is not hindered by the pendency of such cases, which have been detailed by the learned special officer in the fifth interim report filed in court today. While disposing of the pending arbitration cases, the Divisional Commissioner Malda Division shall not grant unnecessary adjournments to the parties, and the time frame as stipulated herein above shall be strictly adhered to. For the purpose of expeditious disposal of the pending arbitration cases, it will be open to the Divisional Commissioner to take recourse to wide publication in at least 2 newspapers, one English and another vernacular, having wide circulation in the concerned districts as substituted service in lieu of the individual service. The cost of publication certain. The next, my lord, paragraph is important. I'm relying on that. We, however, make it clear that pendency of the arbitration proceeding shall not be used as a ground by any of the stakeholders to either delay or stall the widening process of the National Highway. Next, my lord, next 2 paragraphs are not that concerned. So, therefore, my lord, why I am relying on this, that even pendency of arbitration, my lord, has not been made out a proper ground for stalling of a project of national importance. Another judgment, my lord, which I am relying on is reported in All India Reporter 2022 Supreme Court 1531. This is in the case of NG Projects Limited versus Vinod Kumar Jain. This, my lord, is the case was relating to, my lord, tender in respect of a highway construction, my lord. I will be, my lord, drawing your lordship's kind attention to paragraph 10 at page 4. My lord, page numbers are written at the bottom of the pages. Page 4, my lord, paragraph 10. My lord is there. Kindly see 70 is written and on top of the 10, my lord, 10 is a bit small in font. At page 4, yes. I'm placing it, my. We find that the interference in contract awarded to the appellant is wholly unwarranted and has caused a lot of loss to public interest. Construction of road is an essential part of development of infrastructure in any state. The learned single bench and the division bench of High Court were exercising power of judicial review to find out whether the decision of the state was manifestly arbitrary or unjust, as laid down by this court in Tata Cellular versus Union of India, and to act as appellate authority over the decision of the state. This court in Tata Cellular held as under. It cannot be denied that the principles of judicial review would apply to the exercise of contractual powers by government bodies in order to prevent arbitrariness and favoritism. However, it may be clear, my lord, this the Tata Cellular has been, and kindly comes to page paragraph 14. Paragraph 14, my lord, is at page 9. My lord, is there page 9? Paragraph 14 is the first paragraph, my lord.
Yes.
In National Highway High Speed Rail Corporation versus Monte Carlo Limited, this court sounded a word of caution while entertaining the writ petition or granting stay, which ultimately may delay the execution of mega projects. It was held as under. Even while entertaining the writ petition and granting the stay, which ultimately may delay the execution of mega projects, it may be remembered that it may seriously impede the execution of the projects of public importance and disables the state and or its agencies' instrumentalities from discharging the constitutional and legal obligation towards the citizen. Therefore, the High Court should be extremely careful and circumspect in exercise of its discretion while entertaining such petitions and or while granting stay in the matter. Even in a case where the High Court is of the prima facie opinion that the decision is as such perverse and arbitrary and or suffers from malafide and or favoritism, while entertaining such writ petition and or any appropriate interim order, High Court may put the writ petitioner's notice that in case the petitioner loses and there is a delay in execution of the project due to such proceedings initiated by him, they may be saddled with the damages caused for delay in execution of such projects, which may be due to such frivolous litigation initiated by him. With these words of caution and advice, we raise the matter there and leave it to the wisdom of the concerned courts, which ultimately may look to the larger public interest, national interest involved. My lord, why did I, my lord, refer to these two? These are apparently, my lord, has no relation other than the construction of a highway. In this case, my lord, before your lordship, the Honorable Supreme Court was dealing with a tender matter where two people, the tenderer and the state, my lord, were directly involved in the project. The person, my lord, aggrieved had some stake or a financial loss. Similarly, my lord, in the other case, the pending case before the Honorable Division Bench, there some people have stake. Here, the petitioners do not even have any ownership of the land. They are admitted, my lord, settlers here. So today, my lord, the process which has been challenged, my lord, they have a right to challenge. And my lord, we will come up with affidavits. But on the petition of prayer made by people who do not have any title over a particular plot of land, which is admittedly, my lord, a state property, on the plea that we have been there for maybe 30 years, 40 years, my humble request today is your lordship will kindly not pass any order which will, my lord, stop the construction of the highway. And my lord will kindly vacate the order of status quo which your lordship was pleased to pass on the last day. And direct affidavits, my lord. These are my humble submissions.
Okay.
Reply to this.
Yes,
Well, the argument of the state and NHIA well, contradicts each other. But kindly turn to page 48, which the state relies upon. That there must be some basic principle of transparency and fairness. They are the constitutional authorities. Specific Relief Act of Colonial Act is now being implemented when special statute has been there. So kindly come to page 48. Well, kindly see Milord,
page 40.
48, which was led by the London State Council, though Milord contradicted by the NHAI. It has come to the notice of the undersigned that you are an unauthorized occupation of public land and notified and acquired by NHIA. That's why military wanted to get the information from the authority. How did you proceed? Now NHIA acquired the land, and NHIA under the National Highway Act, they are empowered to take possession. Why would they go to the state again?
Lordship, the entire stretch of land has been acquired by National Highway Authority, but this particular stretch was belonging to the state of West Bengal. Hence, no compensation is payable for the same.
May I complete my submission and purely on the question of law? Because factual aspect cannot be contradicted by just oral submission. There has to be something on record. Many things would be revealed. Therefore, this the authority exercised by a subdivisional officer after NHIA has acquired the land is without jurisdiction, number one. And number two, kindly turns to page 103 and 107. Same thing. They are proceeding on the presumption that the NHIA has acquired the land which is pinching me. I am not concerned with the extension of NHIA. NHIA proceed according to the act, empowered them to proceed. That's the basic thing.
Page 109.
107.
107. Yes.
But what is the act? Kindly see the notice. পশ্চিমবঙ্গ সরকারের জমি আইন উচ্ছেদ ও অনুমোদিত অধিগ্রহণ ৬২ পক্ষ থেকে সরকারি জমির অনুমোদিত অধিগ্রহণের কারণ দর্শানোর। তারপর this again a notice for acquisition. Parallelly, two statutes cannot be taken.
No, this is not a notice. This is not a notice of acquisition. This is a West Bengal Unauthorized Occupants 1962 Act.
Kindly come.
Yes,
yes. Therefore, they say সরকারি জমির অনুমোদিত অধিগ্রহণের কারণ দর্শানোর।
This is eviction, my lord. Grateful. This is eviction notice.
But again,
Yes.
let me read the language of notice, not our interpretation. Again I am reading. পশ্চিমবঙ্গ সরকারের জমি আইন উচ্ছেদ ও অনুমোদিত অধিগ্রহণ. The act is eviction and acquisition. ৬২ পক্ষ থেকে সরকারি জমির অনুমোদিত অধিগ্রহণের কারণ দর্শাবে।
No, that is so.
অধিগ্রহণ, we cannot acquire a land. অধিগ্রহণ has a specific legal meaning.
No.
Anyway, my lord, the NHIA says they have not acquired. State says that NHIA has requested us, we have handover. And my lord, the eviction of a person, my lord, who has been having his livelihood for more than 30 years, not a matter of joke. Constitution doesn't permit it. You have to do it strictly according to law.
You are the occupier of that land for 30 years.
I am the occupier of the land for the last 30 years.
Ashun.
Well, I am running my business there. Still, am I running with? They want to evict me by force by blocking my access. Kindly remove. Ask them to remove the blockage from my ingress egress. Then let them proceed.
Call this people to.
Land of the petitioner.
Uh, Can 1 of 2026. This is an application seeking direction upon the respondents and its main and agents, employees, officers and unauthorized persons to immediately remove the soil/sand dumped in front of the petitioner's shop premises located at Chaparir Pad 1 and 2, Gram Panchayat, Alipurduar Block 2, District Alipurduar, adjacent to the ongoing project of 4-lane highway construction on 41-kilometer stretch between Salanlabadi and Palakata and restore free ingress and egress. The petitioner filed the writ petition
Very good, very good.
challenging
Very good, Ghose.
the notice dated 5th September 2022 issued by the District Magistrate Alipurduar for
No. This is issued by the subdivisional magistrate
Subdivisional Magistrate,
and subdivisional officer Alipurduar.
Subdivisional Officer Alipurduar
Is it-
for this is notice for
This is
eviction.
a notice, my lord, under section 3(1) of the West Bengal Public Land Eviction
Under-
of Unauthorized. This is for the hearing notice, my lord.
Issued for hearing under the West Bengal,
May I hand over the act to your lordship?
West Bengal
I'm sorry, my lord, it is a little marked there, my lord.
Public Land Eviction of Unauthorized Occupants Act 1962. In the instant application, the petitioner contends that due to such work of construction, the ingress and egress of it to his shop has been obstructed by way of dumping of soil and sand. Mr. Vikas Ranjan Bhattacharya, learned senior advocate appearing for the petitioner applicant, submits that the work of construction of road has been undertaken by the National Highways Authority of India, within bracket in short NHAI. Therefore, the notice, impugned notice dated 5th September 2022 for eviction and acquisition is bad in law on the face of it, for the reason that section 3A provides the procedure by which the NHAI authorities to acquire the land. The state has no role to play so far as the acquisition of land by the NHAI is concerned. Moreover, the petitioner is running her business, is in occupation of the land in question upon carrying on business for the last 30 years. And therefore, she cannot be evicted arbitrarily without due process of law. Mr. Dipankar Das, learned advocate, appearing through virtual mode on behalf of respondent NHAI, submits that the NHAI has not acquired the land in question and it belongs to the state. Mr. Kunaljit Bhattacharya, learned additional government leader, submits that the petitioner is in illegal occupation of the land in question. The land belongs to the PWD roads.
To the government.
To the government. Notice have been issued, the impugn notice has been issued for eviction of the petitioner. Further, the relying on the decision of Honorable Supreme Court.
My lord, may I just be permitted to interrupt, my lord? After 3-1, my lord, notice of eviction has been passed under section 4-1. That is also there, my lord.
He also submits that
That notice has not been disclosed.
We are yet to file our affidavits, my lord.
Then
that after P1
Yes, my lord.
notice,
Since they could not produce any documents, my lord, under 4-1, the notice was issued.
notice under 4-1.
4-1, my lord.
After issuance of notice under 3-1 of the Act of 1962, notice has also been issued under 4-1.
Yes, my lord.
How do you scroll this?
My lord, with 2 fingers right.
Oh, thank you. No, this is collected. I
Right, my lord,
suppose.
yes. Like pages, my lord, we are.
Okay, 4A, 4-1 is top.
Yes, my lord. It's again marked, I'm sorry.
Yeah,
my lord.
4-1. Notice under 3-1, comma, notice under section 4-1 of the Act of 1962 has also been issued by the authority concerned. Relying on the decision of Honorable Supreme Court passed in Hemant Gupta NG Projects Limited versus Vinod Kumar Jain, reported in AIR 2022 SC 1531, he submits that when a project is of public importance, the High Court should be extremely careful and circumspect in exercising its discretion while entertaining such petitions and or while granting stay in such matters. Therefore, the interim order as sought for by the petitioner ought not to be granted, and he seeks for vacating of the order of status quo which was earlier passed on 11 June 2026. He seeks to file affidavit in opposition to the writ petition. Stop.
The next date, okay.
It is not in dispute that the petitioner is in occupation of the land. As informed by the learned additional government leader that notices under the Act of 1962 under section 3(1) and section 4(1) has been issued to the petitioner. In it 14th court report we get. Therefore, bearing in mind, in National High Speed Rail Corporation, para 14. Bearing in mind that the admittedly, the land in question falls within the stretch where the extension of national highway is being undertaken. Bearing in mind the observation of the Honorable Supreme Court in NG Projects Limited as well as in National High Speed Rail Corporation Limited, since the project involves public importance, this court is
Interim.
not inclined to allow the interim relief as sought for in the application. Accordingly, can 1 of 2026 stands dismissed. Read WPA 2824 of 2022. NHAI, Mr. Das will file any opposition to the writ petition?
Yes, Your Lordship. And Lordship, I have one submission. Your Lordship had recorded that the land has not been acquired. My submission that National Highway has not acquired the land. The land has been acquired, Your Lordship, but no compensation is payable since this land belongs to the state of West Bengal. That was my submission.
Okay, change on the land has been acquired, but since it belonged to the state authorities, no compensation has been paid from the end of the national highway.
Lordship.
Since the land belongs to the state, hence no compensation has been paid. Let such Mr. Bhattacharya, learned additional government leader, as well as Mr. Das, learned advocate for NHAI, seeks to file affidavit in opposition to the writ petition. Let such affidavit in opposition be filed within a period of
4 weeks, my lord.
then it goes to the next.
They have to restore me back if I win. How would they do this?
Within a period of 2 weeks, because you have the documents.
Yes, 2 weeks.
2 weeks they will be
have
filing,
some
so
of the
it will come up
documents.
after 4 weeks.
Yeah, very well.
Document, 2
2
weeks you
weeks.
file your, they get the opportunity to file reply.
Yes, yes. Sir, I cannot file in a lesser time.
Within a period of 2 weeks,
2
Mr.
weeks,
Bhattacharya,
2
they will find their opposition. Reply, if any, be filed within a period of 2 weeks. Liberty is granted to the parties to mention after expiry of the aforementioned period.
But only one observation will note that the steps taken in the meantime shall abide by the result of the writ petition. Otherwise, they will say there was
That is
no.
implied.
That is deemed.
That is implied. And my
It's
lord has
not
been,
always
pleased
implied.
to-
My lord has been
No, no,
pleased
no,
to-
Mr. Bhattacharya, not now.
Very well, very
My lord
well.
has been pleased to dispose of can one
Shan 1 is disposed, file your opposition.
to the writ petition.
Yes.
And my lord, the interim order has been vacated.
Order dated 11th June.
Once the application
Will
is
also
dismissed,
stand
automatically vacate.
Can vacate.
Grateful, my lord.
Thank you, Mr. Bhattacharya.
Obliged.
Done.
Item 6.
Item
For the
number 6,
petitioner.
yesterday the matter was adjourned for
Yes.
instruction, my lord. Kindly make it Thursday, my lord. We have intimated that here, my lord,
On?
the interest on gratuity matter.
Uh,
And for
Kindly
the
make it
applicant lodge.
Thursday, my lord. In the meantime, we will take instruction. That this
Thursday,
time stay.
Mr. Arijit Ghosh, learned advocate for state respondent seeks accommodation to take instruction. This is matter 18.
6K.
Next.
Item 7.
7 minutes I am for the petitioner. And my PR is the interest on gratuity minute only. Okay, the petitioner is the widow of the employee, my lord. He died, my lord, on 17th June 2021. And my lord, TPO was issued, my lord, 17th May 2022.
Revised.
No, only single, not revised.
Single.
Yes, single. Kindly see the TPO. Page 16, 17.
Interest on gratuity
Only gratuity.
only.
Only.
When did he retire?
By 17 June 2021.
Not treated, die.
Not it died.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks interest on area gratuity both or only gratuity?
Only gratuity. PRA, minute.
Area also?
PRA. Delay payment of gratuity. Interest on delay payment of gratuity.
So prayer B?
PRA, not pension, not allowed. That is family pension.
No, you have prayed for area pension also?
No.
Yes, clause B. Mentioned therein.
This is death case, minute, or not pension, minute.
You are
Only
seeking for gratuity or area pension?
Only gratuity. Interest on only.
Only gratuity?
Only gratuity.
সব জায়গায় দেখেছি। Gratuity, yeah? The petitioner contains that her husband was an assistant teacher of Tufanganj New Town Netaji Vidyalaya, district Kuch Bihar. Who died in harness on 17 June 2021. Who died in harness?
Yes, we do. Paragraph 7. Paragraph 7A.
The petitioner, the pension payment order was issued on 17th May 2022. The gratuity amount was disbursed on
At
25th May 2022.
25th.
However, no interest was paid, hence this writ petition. Mr. Devojit Kundu, learned advocate for the petitioner. The submission থাকবে ওটা থাকবে পরে একটা অ্যাড করুন কি further he does not praise for prayer B of the writ petition. He does not praise for prayer B of the writ petition. For interest on arrear pension. Prayer B of the writ petition for interest on arrear pension. Bucket the same. 6 weeks, 8%. Disposed. From delay clause from the date of death, following the date of death till the date of actual payment.
8.
For the petitioner, Lordship.
Kindly see, my lord. The date of retirement was 31st December 2024. Plus PPO issued March. But they have come only minimum time should be given to us, my lord. But this type of petition should be rejected. My lord, otherwise the at
When
least
did it retire?
minimum 6 months should be given.
31st of December 2024, Lordship.
PPO issued 4th March 2025.
Yes, Lordship, it's been in 1 year, Lordship.
1 year.
PPO was issued on 4th of March 2025, Lordship.
3 months.
Apology. It's a 25.
2025.
Yes, my lord. Only 3 months, not 24. 25. Yes, my lord.
2 months, some days.
2 months should be rejected, my lord.
2 months, some
Lordship,
days
kindly
only.
consider, Lordship,
This
this
type of
person
petition,
has been in
otherwise,
service for so long
time
time,
should be
Lordship,
given,
and this
my
is when they are.
I used to, there are 6 months limitation over there. Before 6 months should not be given. At least minimum time should be given to us.
There is no delay.
Yes, your lord.
Yes.
Lordship, kindly consider, Lordship, it's been then, this person is asking for his genuine payment, Lordship, it's been disbursed by the state.
6 months
Lordship, kindly
minimum.
consider,
Minimum
Lordship.
time should be given to us, my lord.
Retired in 2024, 2025.
2 months, 2 months.
I'm saying yes.
What a दिन date. I'm helping it here.
এটা ছিল না আপনি বলছিলেন? এগুলো তো দিলে না দিলে মিনিমাম একটা সময় দিতে হবে। 3 মাসও নয়, 2 মাস, 2.5 মাস। দিয়ে দেবো? Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for interest on gratuity and area against delayed payment. 6 direction of responding authorities. The petitioner contains that he was the head teacher of
Dipli Primary School.
Dipli Gaon Primary School, Post Pipli District, Darjeeling. The petitioner retired from service on superannuation on 31st December 2024. The pension payment order was issued on 4th March 2025. The gratuity and arrear pension amount was disbursed on 22nd March 2025. However, no interest was paid, hence this writ petition. This one's the same submission. Mr. Orijit Ghosh, learned advocate for the state respondents, submits that there is no such delay and therefore the writ petition should be dismissed in limine.
2 months, my lord, kindly be recording, my lord. Otherwise, the time period
Has been there is no such delay as the pension payment order has been issued within 3 months, no?
Yes, my lord.
Within the 3 months. 3 months. March আছে। 4th March, or the 31st, within almost 2 months. So there is no such delay. Upon going through the contention of the writ petition, it is found that there is delay of more than 2 months. It is the bounden duty of the state to disburse the pensionary benefits to the employee forthwith. Interest grant. But allowed. For the 2 months later. Good. Have fun. Next.
9 also, Lordship, and for the petitioner, Lordship. This is for single gratuity and arrear, Lordship.
Only gratuity.
Gratuity and arrears. Interest on
What is
gratuity
the
and
delay?
arrear. Lordship,
When
the
did he retire?
petitioner was an assistant teacher and he retired on 31st of January 2023, Lordship. Kindly comes to page number 3, paragraph 2. He was an assistant teacher of Lebong Primary School, Lordship. Lordship, the PO was issued on
File the
10th of
affidavit
January
of service.
2025.
File the affidavit of service.
Lordship.
31st January 2023 retirement. The school in নাম হচ্ছে Lebong Primary School, Post Lebong District, Darjeeling. PPO issued on 10th January 2025. Disbursement of gratuity and pension date হচ্ছে 11th April 2025. However, no interest was paid. Hello, 6 weeks.
In Lordship of the petitioner, Lordship, the petitioner retired on 30th of June 2024, Lordship. PPO was issued in the 1st January 2025.
Did donation?
Yes.
30th June 24. Shikha
Yes,
Sangha High
Lordship,
School,
so
post with
he was retired in 2024, Lordship, and PPO was issued on 2025 January 10th.
30th June 24. PPO issued 10th January 25.
25, Lordship.
Name of the school is Shikha Sangha High School, Post Lebong District, Darjeeling. Disbursed on
Disbursed on Lordship on 12th of March 2025.
gratuity at area.
Arrear. Eleven also, Lordship, same for the gratuity and arrears. Single PPO, Lordship. The petitioner was retired on 30th of June 2024. PPO was issued on 28th of January 2025.
School is Gyanpit
Was it assistant teacher of Rangpi Janopit's High School, Darjeeling, District
Post
Darjeeling.
Mangpur District, Darjeeling. Retirement date 30th June 2024. PPO issued on 28th January 2025. Disbursement date 25th March 2025. Rest same.
Well, similar, Lordship. Similar, Lordship. The person was retired on 2021, 28th February of 2021. PPO was issued on 5th of August 2021.
Petitioner contains that she was appointed as assistant teacher.
RKSP Primary School.
RKST Primary School, Hooker
Road,
Road,
Darjeeling.
District, Darjeeling. Retirement 28th February 2021. 5th August 2021. Disbursement of gratuity and arrear 22nd August 2021. The rest same. Affidavits will mention.
13 Lordship, similar, Lordship. The person was retired from his service on 28th of February 2025. And PPO was issued on 14th of August 2025. It was a assistant teacher in Jalpaiguri
Retirement
High.
February 25. He or she?
He
was an assistant teacher of Jalpaiguri High Secondary
High.
School, post Jalpaiguri District, Darjeeling. Retirement date नहीं है 14th August 2025, PPO issue 12 September 2025, gratuity and area amount disbursed. The rest same 6 weeks, 8%.
Single PPO.
From the date
Similar,
following the
similar.
date of retirement till the date of actual payment. Next.
Similar lawsuit.
6.
Similar lordship. This is also single PPO. Petitioner retired on 31st of January 2021. And PPO was issued on 17th of November 2021.
31st January 21.
Yes, he was a clerk.
He was a clerk of
Taliaguri High School,
Jalpaiguri
Coach Bihar.
High School,
Toliaguri High
District,
School.
Coach Bihar. Pension payment order issued on 17th November 21.
21. And disbursed on 12th of
Gratuity and area pension amount
Yes.
disbursed on 12th
12th of
December
December
2021.
2021.
Following the date of retirement. State আছে তো জানে?
15 similar lordship. Single PPO. Single PPO. He was retired on 31st of October 2019. He was the assistant teacher of Uttarpara SP High School, District Coach Bihar. The PPO was issued on 17th of
Date of retirement
February 2020. February 2020. And the amount was disbursed on 4th of April to 2020.
PPO issued Milord 17th February.
2020.
Disbursement April.
Retirement Milord the 31st 10th 2019.
October.
4 months, 4 April, 6 months. Disposed of.
16.
Similar lordship, 16.
Your Lordship,
She
in
was
this matter also, there was only 2 months delay, Your Lordship. Kindly,
lordship, similar prayer that they are asking for the genuine payment lordship. That should be disbursed from the date they are retired.
February, 4 months.
She retired as an
October.
assistant teacher, high school,
Wait.
Sharuda High School, Mangpo, Darjeeling.
31st October 24, BPO 10 January 25, 12 February 2025, gratuity and area. Next.
17.
17 lordship, this is die in harness, single PPO. The husband of the petitioner was a husband of
Affidavit
PPD
of service filed
assistant
on behalf
teacher.
of the petitioner is
And
taken on
he died
record
on 21st
by
of
the present writ petition. Jathake, the petitioner states that her husband was an assistant teacher of Chhadparo Chowki AP School
School,
District, Coach
Coach
Bihar, who died in harness on 21st June 2024.
lordship.
The pension payment order was
10th of
issued on 10th February 2026. The
disbursed order was on
the
13th
gratuity
of
and area pension amount was disbursed on 13th February 2026. However, no interest was paid, hence this writ petition. Is sufficient same from the date following the date of death till the date of actual payment. Any disposal. Sorry.
lordship.
Next.
18 lordship. This is gratuity in arrears. Revised PPO for under ROPA 2019 lordship. Petitioner was retired on
The
30th
petitioner
of
contains
September
Ropa Ropa to niye
2019.
nebe na? The petitioner contains that he was assistant teacher of Alipurduar Girls High School. She hobe.
She, Lordship.
The petitioner retired from service on superannuation on 30th September
September
2019.
19. Date of issue was the
The
Lordship
first pension payment order was issued on 14th November
2019.
2019. The revised pension payment order under ROPA 2019 was issued on 29th December
December
2020.
2020.
The revised gratuity and arrear pension amount was disbursed on 11th January 2021. However, no interest was paid, hence this writ petition. Baki ROPA de ja thake from the
Grateful,
date
Lordship.
of effect of ROPA 14th
2019.
February 2020 till the date of actual payment. Disbursed.
Grateful, my lord.
19 also, Lordship. This is for single PPO, gratuity and arrear, Lordship. Petitioner retired on 30th of November 2024.
Retired on 30th
He was a
November
teacher in charge
24.
of Deodanga High School, District Alipurduar. And PPO was issued on 18th of July 2025. Disbursed on 21st of July 2025, Lordship.
Baki the same, huh? 6 weeks, 8% from the date following the date of retirement till the date of actual.
Lordship.
20.
Similar, Lordship, for single, this is also for gratuity and arrear, single PPO. She was retired on 31st of March 2024. Issue was, PPO issue was
31st March
20th of
24.
February 2025.
Wait, assistant teacher of Mona Primary School, post Top Hana District, Darjeeling.
I have my brief. I think
The petitioner retired from 31st March 2024.
2004.
PPO 20th February 25. Gratuity and arrear amount disbursed on 12th March 2025.
Number plate is number.
The rest same 6 weeks, 8% from the date following the date of retirement till the date of actual.
Twenty.
21, Lordship. This is an dine harness for single PPO, gratuity and arrear. Husband of the petitioner, Lordship, he was in Group D staff in Jadavpulli High School, District Alipurduar. He died on 26th of July 2025. PO was issued on 28th of January 2026 and it was disbursed on 3rd of February 2026.
Date ko niyechen? The petitioner's husband, petition contains that her husband was approved Group D staff of Jadavpulli High School, District Alipurduar. The petitioner's husband died in harness on 26 July 2025. The pension payment order was issued on 28 January 2026. The gratuity and arrear pension amount was disbursed on
3rd
February 2026. However, no interest was paid. The rest same. 6 weeks, 8% from the date following the date of death till the date of actual payment.
22.
22, Lordship, single PPO, gratuity and arrear. Revised PPO for under RUPA 2019.
22.
Petitioner was retired in 31st of December 2026. 2006, Lordship. Stand corrected, 31st of December 2006. That's revised too. PPO was issued 2008. No, revised. 2009, it's for revised. 2009. So application is for revised.
ROPA 2009 effective already February, no? When did ROPA 2009 came into effect?
Lordship.
I'll make it not tomorrow.
Just give me 2 minutes, Lordship.
Yeah, ROPA 9 ने दिखले क्या होगा?
जिला परिषद employee.
The petitioner
1st January
2006, Lordship.
2009 ROPA given effect from 2000?
Yes, sir. 2006.
No. देखे नहीं check करो.
I'll make it not tomorrow. I'll.
इटे काल के रखो.
हाँ.
अगर देखे
Not.
Huh? Not really, no.
এটা রাখুন 23
23, Lordship, is tie-in harness, Lordship. It's for revised PPO, gratuity and arrear, Lordship. The husband of the 2019. The husband of the petitioner was the assistant teacher in Vidpara, Parapar High Primary School, District Alipurduar. He died on 18th of March 2017.
The petition contains that her husband was an assistant teacher of Birpada
Parapar Primary School.
Birpada under Parapar Primary School, District Alipurduar, who died in harness on 18th March 2017. The pension payment order, first pension payment order was
17th February 2020.
the revised pension payment order under ROPA
21st of
19. ROPA 19.
First
21st January 2021. The revised gratuity and arrear pension amount was disbursed on
28th of
28th
January
January
21.
2021. No interest paid.
Grateful of it.
24
24, Lordship. This is also die-in harness, single PPO 2000. No, single PPO gratuity and arrear, Lordship. The husband of the petitioner was in service. He was the assistant teacher in Shonari Nikutiar Kuthi New Primary School, District Coach Bihar. He died on 16th of March 2024. The
What about
PPO,
the other petitioners?
Lordship, the wife is the
21.
Lordship, he has just 2 minor sons. Wife is the first.
To the extent of their share,
Yes.
একজন কি petition করে? What
The
about the
wife
mother,
still-
father, son?
Sons are the minor, Lordship.
Kindly
So
make it not to
the
the
mother is the natural
Take
guardian.
instruction that
So
also.
Lordship, still the wife is she is alive, Lordship. So she is the first person to receive the
The
gratuity.
share has been
Share.
given.
Yes,
She
Lordship.
does
This
not have
minor
the
share,
entire
the minor
100%.
son's share has been protected by only the wife because she is the natural guardian of this minor. Twos are already in this. Lordship, then
Kindly make it not to the after instruction will be clarified.
You have to make, what about the mother and father? What about their right?
that I have to take instruction whether they are alive or not.
On the joint prayer of the Parties list this matter before the next available circuit bench. Go through the petition, who are the parties,
Yes.
file an application. Next circuit. Next.
25.
Lordship. Single PPO graduating area. It's a revised PPO for under RUPA 2019. Petitioner was in service and he was retired on 31st of March 2019.
এটা কত number? What is your PPO?
It's annexed, Lordship.
RUPA, yes.
It's Chalan, yes. Lordship, annexure T19.
When did he retire?
He retired on 31st of March 2019.
31st March.
31st March.
Single PPO.
Single PPO, Lordship.
Oh, you retire করছে তখন রোপা তো effect হয়ে গেছে।
March. So initially, Lordship, it was issued on 2009. The revised order was issued on 4th of August 2021, Lordship. Probably the comes in the 2019 RUPA comes in effect later. So the first issue PPO was issued under 2019 guidelines. Then later on it was revised. And that revised order was issued on 4th of August 2021.
What is revised?
Pair number 5, Miller. Page number 3.
Yes, para number 5, page number.
What is the first one then? First pension payment order?
First pension payment order on 19th of March 2019. So it was issued before the 2019 RUPA come into effect.
Let it annexure P1, Miller.
Annexure P1 is not the PPO, it's a forwarding letter that the PPO is
Yes.
That they have.
with effect from 1st April 2019.
That the date has been given, 19.
Effect to cover-
19 RUPA effect from 2016. Initial RUPA effect হচ্ছে 2016
It's March.
It was a time again because.
February.
Which is the area amount? Revised. February এটা ডেটটা দেয়নি কবে রিটায়ার করেছে
Retired on 31st of March 2019.
14 February থেকে ডিভিশন
Yes, but Lordship.
The petitioner contains that he was an assistant teacher, sorry, assistant inspector of schools, primary section, district Kuch Bihar. The petitioner retired from service on superannuation on 31st March 2019. এগুলো কেন হতো না? Inspector of Schools. Mr. Ghosh, the petitioner is the Assistant Inspector of Schools. Is it to lie before the SAT or this? Is this application live before the tribunal?
I will take instruction.
Assistant instruction, inspector of school.
No, the single PPO has not, initial PPO has not been added. I have
He's
to
not
go
taking
by
instruction.
Mr.
Mr.
Retirement has
Purijit
not
Ghosh,
been added.
learned advocate for the state respondents, give the affidavit, seeks accommodation to take instruction. Take this matter before the next available circuit. Next.
Number 26.
I am for the state.
I am for the petitioner, I am for the private respondent. In the case of unauthorized construction, I have made a presentation before the concerned authorities regarding the unauthorized construction of 3 buildings, each being one is 5-storied, one is 3-storied, and 2-storied, constructed by the private respondents lordship. My representation is pending consideration from the end of the
Private
concerned
respondents over their own
lordship.
land. Over their own land.
No, the land of
The
the
entire
DI fund.
land belongs, the entire area belongs to DI fund, this
DI
Darjeeling
fund.
Improvement Fund. Entire area,
They don't have a building.
even the
plan.
land of the petition.
Without the sanctioned building plan.
My lord, I appear for the state, my lord. Now, as per instruction, my lord, on 8, notices were issued to the private respondents, my lord. And as per, my lord, kindly says as per notice, this is notice of inquiry addressed to the 3 private respondents that an inquiry inspection is been scheduled on 12 June 2026 at 11 AM, my lord. Now,
After that,
my lord, on 8 June again, the executive officer of Patigada Panchayat Samiti, my lord, had requested the additional executive officer, Siliguri Mahakuma Parishad, my lord.
you have also encroached.
No.
Yes.
No.
So there, my lord,
Where
The entire
is their
Mocha belongs
complaint
to
against?
this-
Where
Darjeeling
is their complaint
Entire
against?
Mocha.
it is under the Darjeeling Improvement
Yes.
Fund.
Darjeeling Improvement Trust.
So,
What locus he has, I do not understand.
so there, my
So
lord,
they will raise a building without a building plan.
We are deciding there since 70
3-storied,
years.
5-storied building,
You
3-storied.
have also raised unauthorized
Yes.
construction.
Yes.
Lordship,
You have also raised
where is
unauthorized.
the complaint to that effect?
Even if not, there is no
where
complaint.
is
They
the
are now
complaint to
alleging
that
that your
effect?
land is also.
I have
My
made
lord,
this, I have made this complaint before the authorities on lordship in the month of February.
here, my lord,
If
the
they are aggrieved
for
by my
technical
with my
officer was
building,
requested
where
to
is
be
the
present
complaint?
for the inquiry, my lord. Thereafter, my lord, the inspection was held on 12th of June 2026. May I hand over the inspection report, my lord? My lord. My lord, as per this inspection, my lord, none of them have the sanction plan of the buildings, my lord.
What is the name of the petitioner is?
Petitioner is, my lord,
Prashant
Prashant
Vikram.
Vikram. Petitioner was not given notice, only the private respondent.
Pursuant to my complaint, the inquiry was closed.
Pick and choose.
No, we received, my lord.
Steps. You take steps against his client.
My lord, what I'm humbly submitting, my lord, since this is before an authority, my lord, kindly direct to, that is the authority
No,
to
the
hear
author-
us, my lord,
No,
and pass a reason order.
the authority, my lord, after that, I am, my lord, relying on the West Bengal Panchayat Act. Now, under section 100, Panchayat Act ache? Kindly comes to 100 section 114A.
Yes.
My lord, I'm placing subsection 1 without prejudice to the generality of the power under section 114 and notwithstanding anything contained in section 23, 24, 25, the state government may in the public interest declare by notification its intention to prepare and publish a development plan in respect of an area within the jurisdiction of Panchayat Samiti in accordance with such procedure as may be prescribed in or in accordance with the provisions of any other law for the time being in force, and upon the issue of such notification, no new structure or new building, irrespective of its plinth area or height, shall be erected or constructed, and no addition to any structure or building shall be made in such area except with the permission granted by the Panchayat Samiti or any authority as may be empowered by the Panchayat Samiti in this behalf, and except in accordance with such specification and conditions as may be prepared and published by the Panchayat Samiti or such other authority as the case may be. My lord, pausing here, my lord, my instruction is that by notification, this area under the Darjeeling Improvement Fund area, my lord, is under the Panchayat Samiti. Or else my lord knows that in a Panchayat area, this function is done by the Pradhan or the Panchayat, but in respect of this particular area, it is done by the Panchayat Samiti. Now, my lord, kindly comes to subsection 5 of section 114A. My lord, is there? Yes. Where any new structure or new building or any addition to any structure or building is being or has been erected or made as the case may be in contravention of the provision of subsection 1, the Panchayat Samiti shall refer the matter to the subdivisional officer concerned, who may, after giving the owner of such building an opportunity of being heard, make an order directing the demolition of the building or a portion of the building as the case may be by the owner within such period as may be specified in the order, and in default, the subdivisional officer may itself effect the demolition and impose a fine as may be specified by the state government and recover the cost thereof from the owner as the public as a public demand. Now, my lord, my humble submission is that subsection 1 has been complied with. Inspection has been done, a report has been prepared in presence of the persons who have alleged to have constructed without sanction plan. Now, my lord, they will get a chance of audience as per section 5 before the subdivisional officer, the next stage.
Okay.
So that will be the natural progress of the case, my lord. So these are my humble submission, my lord.
So this inspection report has been submitted by whom?
This has been submitted. This was done by the block development officer, my lord. Inspection report.
Assistant engineer.
Oh, no, inspection report देनी.
Its inquiry inspection is being
It is
scheduled.
by junior engineer, Mahakuma Parishad, my lord. Or else, my lord, a fresh inquiry can also be directed by your lordship.
Planning section for a joint inquiry. Yes.
These are initiated by the block development officer. Matigada block.
Video is the ex-officio executive officer of the Matigada Panchayat Samiti.
Yes, yes. The inspection was done by the assistant engineer, junior engineer.
This report has been submitted before the executive officer.
Yes, before the block development officer, my lord, and he has, my lord, forwarded for your lordship's kind perusal.
Now he has to forward the same to the subdivision
Subdivision
officer who will
officer.
cause a notice.
And yes, my lord.
Subdivision officer party.
Yes, yes, possibly.
Subdivision no. No, my lord.
No.
The video is the party. The district magistrate is the party.
The district magistrate does not have a role, right?
It is the inquiry, no office. The process of financial plan. Anything else? Okay. Executive officer is a party.
Yes, yes,
Yes, yes.
yes. The video is the executive officer.
So executive
Respondent
officer
number
is
five.
directed by
Respondent number five.
disposing this writ petition, directing executive officer to take steps in accordance with 114A clause 5.
Grateful.
He will pro-
And they will also get chance
Yes,
of
yes.
hearing before.
The affidavit of service you have served upon the private respondents.
Lordship?
Service.
Well, I am
Yes,
for the
they are
private.
My lord,
I am for the-
By the present writ petition, the petitioner seeks direction upon the respondent authorities for demolition of illegal and unauthorized construction undertaken by private respond number 7, 8, and 9. In terms of provisions contained in West Bengal Panchayat Act 1973 within bracket hereinafter referred to as the Act of 1973. The petitioner contains that the
না ইয়ে এসডিও কে পাঠানো না না ও স্টেপ নেবে ভিডিও স্টেপ নেবে
videos
হুম
private respondents have undertaken unauthorized. You are residing in the same locality. You have not stated your what is your stand. You are there as in which paragraph you have stated? Let's see, yes. Para 2A. Para 2A, page 8. The petition contains that the petitioner jointly with other legal heirs and successors of one late Dhanmaya Brahmani are the true and lawful lessee of landed property at measuring 1,88, দেখে নেবেন 2A তে আর দাগ দিন Matigada, and they are peacefully occupying and holding the same to the knowledge of all concerned. The land comprised within Moja Matigada Hut Street, sheet number 1, jail number 80, belongs to Darjeeling Improvement Fund governed by the rules regarding management of Darjeeling Improvement Fund. The private respondents number 7, 8, and 9 have illegally and unauthorizedly raised construction of 3-storied buildings construction of buildings over the land belonging to the Darjeeling Improvement Fund. On which is your complaint?
Yes, my complaint is at page 45. Is dated
17 February 2026, the petitioner submitted a complaint before the block development officer is the authority.
Yes.
Block development is the authority.
Yes.
To decide the complaint.
Officer of Matigara Panchayat.
The block development officer, Matigada Development Block, along with other authorities, seeking redressal of his grievance. However, since no steps were taken, hence this writ petition. Mr. Devorshi Dhar, learned advocate representing the petitioners, submits that appropriate orders be passed for demolition of the illegal and unauthorized construction undertaken by respondents 7, 8, and 9. Mr. Kunaljit Bhattacharjee, learned additional government leader, submits that upon notice to the private respondents, inquiry has been conducted and inspection report has already been submitted before the respondent number. Executive officer is respondent number? Five. Executive officer, Matigara such and such. Referring to section 114A subclause 5 of the Act of 1973, he submits that the executive officer, who is the executive officer of Panchayat Samiti, is to refer the matter to the subdivisional officer for further course of action. Since no sanction plan could be produced during inquiry by the private respondents.
Kindly record my submission also, my lord. Well, I'm denying the allegation, my lord. I've been reciting them more than 70 years, my lord.
Namanpur Pal,
And these are old
advocate
buildings,
for
my
the
lord.
private respondent submit, denies and disputes the allegations made in the writ petition. However, he concedes that if the hearing is held by the subdivision officer in terms of 114A subclause 5 of the Act of 1973, he has got no objection, subject to the notice being served upon his client.
My lord.
Right.
And I shall submit
It is-
all supporting
it
documents.
is not in dispute that inquiry in respect of the complaint of the petitioners has already been made by the assistant engineer, West Bengal SRDA. What is the full form?
My lord.
West Bengal WB SRDA. In inspection report in the second page,
Engineer, my lord, I don't know the full form, my lord. Inspection report.
by WB SRDA,
SRDA কোথায় দেখছি?
it is informed by the learned additional government leader that such report has already been submitted before the executive officer.
SRDA.
State Rural Development Agency.
নিজে বানিয়ে
কেন?
হচ্ছে ফোনটা।
The report reveals that no sanctioned building plan could be produced during inquiry. Therefore, the executive officer of the Panchayat Samiti, concerned Panchayat Samiti, is to take steps as per clause 5 of section 114 capital A of the Act of 1973. Accordingly, এই একটাকে clause 5 টা কোট করে দেবেন দিন। I'm keeping this book. বইটা আমাদের? আচ্ছা। In view of the above, respond number such and such is directed to refer the matter to the subdivisional officer.
মাটিগাড়া হবে নাকি ওটা?
মাটিগাড়া।
Respondent হচ্ছে executive officer.
No, he is
chief
not,
executive.
SDO is not a party, my lord. SDO Shiliguri. Shiliguri to.
The topic
Hmm,
hearing
Shiliguri.
on the prayer of the learned advocate for the petitioner, leave is granted to implead subdivisional officer Siliguri. Siliguri as a added respondent number 10 in the instant writ petition. Refer the matter to subdivisional officer
শিলিগুড়ি, SDO শিলিগুড়ি।
Siliguri added respond number 10
देवश्री board पे इसका
to take appropriate steps as per clause 5 of section 114 capital A of the Act of 1973. And issue notice to the parties and hear them and dispose of the complaint in accordance with law. Liberty is granted within a period of 6 weeks from date of communication of the order. Liberty is granted to the parties to produce relevant documents at the time of hearing.
Grateful.
Executive officer refer করবে sub division officer. This is chief executive officer. Number such.
ঠিক আছে sir. আগেরটা লিভ ছিল যেটা। ছটফট করো। For the state. Yes, sure, on with the petitioner lordship. Appealing for compassionate appointment lordship on 9 hands. In the father of the petitioner died on 6th October 2016 lordship, and application made on 5th January 2017 lordship to the before the BDO lordship.
Yes.
Annexed P1. Annexed P3 page 29 lordship.
Yes.
Thereafter, lordship, the BDO is forwarded the said application to the
January.
Yes, lordship. 5th of January 2017, lordship.
5th January.
Yes, lordship.
Yes.
Forwarded to the district
17th
district Panchayat and Rural Development Officer, lordship, on 17th April 2017, lordship. Thereafter, lordship, the DPRDO Kujibihar on 15th May 2017 sent a proposal for compassionate appointment lordship to the Director of Commissioner of Panchayat Rural Development of the Government of West Bengal lordship. Case 31 lordship P5.
Then
Got it, lordship? With all documents. And lordship, thereafter the Deputy Director sent a letter to the DPRDO Kujibihar lordship to resubmission the some documents lordship.
Yes.
Page number 32, annexed P6 lordship.
returning the proposal for respect of
And lordship, thereafter lordship, on 27th December 2019, Deputy Director PNRD lordship sent a letter to the DPRDO Kujibihar to resubmit the some documents lordship, 3 documents lordship, revised the 3-man inquiry committee report and attested copy of PPO and proof of GAISS receipt, and check memo should be signed as per particular should be maintained regarding the financial dues received as per 3-man inquiry committee report lordship. Dated lordship 27 December 2019 lordship. Page number 33 lordship.
Yes.
And lordship, accordingly lordship, the petitioner submitted the said application as per prescribed format lordship, and 3-man inquiry report and other document lordship. The next are P8 lordship, page number 34 lordship.
So submitted by which authority?
Yes, lordship.
This is submitted by whom?
Submitted to the DPRDO lordship. Submitted by Rafizul Ali at page 35 in Bengali. Rafizul Ali, Yes, the petitioner.
Okay. No, this
And
was
3-man
submitted by the
inquiry report is the page number 40.
3-man committee report. These all have been submitted by whom?
This the application
Before
was
the-
formed, submitted by Rafizul.
To district DPRDO.
Yes, lordship. DPRDO Kujibihar lordship, District Panchayat Rural and Development Authority.
Okay. Then
And thereafter, Lordship,
this is the inquiry report.
DPRD Kosbe sent a letter to the all documents sent to the Director Government of West Bengal, PNRD, Lordship. And page number, Lordship, 42, Lordship, and it's at P9, Lordship.
Okay. Then
Lordship, the DPRDO, then annex at P10, Lordship, page number 43, Lordship.
P-submission.
Submit all documents and annex at P11, Lordship, page number 44, Lordship. The additional director asks for the Lordship original application dated 17th May 2022 and Lordship 15th first application, Lordship, on the plain paper, Lordship, the 15th January 2017, Lordship.
The date is wrong.
Lord, here it is written wrong date, Lordship, mentioned in the said letter, Lordship. Page number 44, Lordship. It should be 15th January 2017, Lordship.
Yes.
Lordship. Thereafter, Lordship, additional Director Panchayat Rural Development sent a letter to the Secretary and Lordship. Lordship, kindly come to the page number 46, Lordship. Additional Director sent to the Special Secretary to the Government of West Bengal for proposal of appointment of compassionate ground, Lordship. Now, the Lordship, thereafter, Lordship, the said pair for the appointment on compassionate ground, Lordship, the rejected on the 2 points, Lordship. The application submitted by the page number 48, Lordship, the rejection order, Lordship. The application submitted by the Rafidul Ali, Lordship, para number 2, Lordship, the on 5th January, Lordship, 2017 for appointment of compassionate ground is merely on a plain paper application, not an application in prescribed format in Annex A, Lordship, which cannot be considered as valid application in terms of notification SWAMSO or Labor Department related with notification SWAMSO, Lordship. This is the only rejection, Lordship.
Okay. Yes.
The petition is filed application within time, Lordship.
The first ground at page 48, which your Lordship has been pleased to see, my Lord, is that the application was made in the year 2017 on a plain paper, my Lord. First, and second, my Lord, the application in the prescribed format was made on 17th of May 2022. Now, my Lord, the few dates are important. The date of death of the father of the petitioner was 6th of October 2016. Then your Lordship kindly comes to page 33 of the writ petition. 33, which my learned friend had also shown it to your Lordship, my Lord. This is dated 27th of December 2019, by which, my Lord, certain clarifications or documents were asked to be submitted by the writ petitioner. Thereafter, my Lord, at page 34 is the application in the proper format, which, my Lord, was filed on 17th of May 2022. The date is at page number 35. Bottom of page number 35.
Yes.
My Lord has been pleased to see that. So admittedly, my Lord, this application in proper format has been filed after 2 years from the date of the death of the father of the petitioner, my Lord. I am relying on a notification of the government of West Bengal, my Lord, where the timeline has been fixed, my Lord. So, my Lord, kindly, I'm sorry it is marked again, my Lord. If your Lordship sees that marked timelines, my Lord is there, it's
Yes.
marked, I'm sorry, my Lord. if the family of the deceased or the employee retired on being permanently incapacitated is in need of financial assistance and the same is absolutely necessary to support the family, application for employment is to be submitted within 2 years from the date of death of the retirement on permanent incapacitation. If no application is submitted within a set period, it will be presumed that the family does not require any financial assistance. Initially, it was within 6 months, it was increased to
2 years.
2 years. Thereafter, my lord, kindly sees on the possibly on the next page, my lord, notification number 278 on the left hand side, my lord. Kindly see notification number 278.
Same page.
Maybe the next page, my lord. I am looking at this soft copy.
The notification 278 is not there.
It is there. Notification. Kindly see. Ito dana, my lord. Yes. I'm sorry, it was the last in the same page it was. Now here, my lord, it says, plain paper application submitted within 6 months can be accepted as valid application provided pro forma application has been subsequently but not later than 1 year from the date of death or in incapacitation of the government employee. The administrative department must be doubly sure that plain paper application was really submitted within the prescribed period of 6 months. This has been deleted, my lord. And my lord, in 2013, the notification I am relying on, here the procedure says, procedure 10B, that application is to be submitted in the prescribed format as in annexure A and B is applicable through head office. Kindly see, my lord. Again, I must apologize, my lord, it is marked. Okay. But department ke bolte hain not to mark in case.
In view of
So therefore, my lord, in view of these two, my lord, my humble submission is there is nothing wrong with the impugned notice. The impugned notice is correct, my lord. The reasons are substantiated by these notifications, my lord, that it has been submitted 2 years after the death of the father of the petitioner in the proper format, my lord. And it has to be filed in proper format as per annexure. A plain paper application will not be taken into account.
Lordship, in this regard, Lordship, I have handed over the one order, my lord's order, Lordship.
Copy.
Copy done.
Reported দেখাচ্ছে পরে দাও তাহলে কপি আমার
Lordship, here, Lordship,
কি নাম
in the read petition, Lordship, 2 points is raised. The applicant was minor at the time of further, Lordship, not in the this read petition, Lordship. And Lordship, late submission of pro forma application, Lordship. In page number 5, Lordship, my lord's order, Lordship. Para number 6, Lordship. May I read it?
substance, not the form. Para 8.
Sorry, my lord.
Para 8. Scheme meant for a beneficial scheme.
My lord, can I go through it and come back after lunch? My lord.
Para 8.
Very well. I
Srijit Ale versus Deputy Director.
Yes.
My learned friend will give
2012, Volume 7, SCC 248.
Yes. There are the several judgment has been passed, Lordship, in this same FX court order.
Let's authorize this, Lord, just a small request. But my matter is
distinguish करेंगे. Yes. My lord, 27, I'm sorry, I cannot go through the orders. Can it be taken up tomorrow? Your lordship's order, my lord, will kindly not take me otherwise, but still.
No, I have heard you.
But those judgments have not gone. But I leave it to your lordship, my lord. Your lordship's order.
What is the ground?
27.
Only because he did not file that format within the prescribed period.
Yes, my lord. As per the gazette notification, he did not, my lord. At page 48, the impugned order.
Lordship, make one order, Lordship, our High Court order, Lordship, passed by the Honorable Justice Subra Bose.
इसको निगेट कर दिया. निगेट कर इसको क्या सपोर्ट उनको सपोर्ट कर. हाँ मतलब बोलने को दे सकता है. और की हो गया भाई. जब बोलता है तो बोलता है.
ये भी बोल रहे कि ब्लैंक पेज में दिया है तो रिस्पोंडेंट का
Same question arises in the said question.
अच्छा क्वेश्चन भी एक बार भी नहीं लिखा कि तुम प्लेन पेपर में क्या.
For the present writ petition, the petitioner seeks for setting aside and or quashing of the letter dated 16 December 2025 issued by Assistant Secretary, Government of West Bengal, Panchayats and Rural Development Department. Respondent number.
Respondent number. The impugned order, my lord.
Yes.
Impugned order is.
No, impugned passed by respondent number.
2, Assistant Secretary to the Government of West Bengal,
Respondent
Panchayat
number
and Rural
2.
Development.
Rejecting the application of the petitioner seeking for compassionate appointment on compassionate ground. The petitioner contains that his father died.
Yes, Lordship, father.
That the petitioner's father, late Jahir Ali, was a Gram Panchayat Karmi of Jalpaiguri 2 Gram Panchayat under Tufanganj 1 Development Block, District Kuch Bihar. The petitioner's father died in harness on 6th October 2016, leaving behind his wife Chakki Jan Bibi and 3 sons, namely Shafiqul
Ali, Mafidul Ali, and Rafidul Ali.
Paragraph 4 to देखना.
Para number 4, Lordship.
The petition, after the demise of his father, submitted an application with necessary papers and documents before Respond number 10, Block Development Officer, Tufanganj 1, Block Tufanganj, one development block. Huh? For appointment on compassionate ground. For his appointment on compassionate ground. Date of the appeal on 5th January 2017. Huh? On 5th January 2017. The application of the petitioner seeking appointment on compassionate ground was forwarded to the district panchayat and rural development officer on 11th May 2017. The district panchayat and rural development officer on 15th May 2017 sent the proposal for appointment of the petitioner on compassionate ground. This was sent to whom?
Which one, Malad? Director and to the Director Commissioner Panchayat Rural Development of the Government of West Bengal.
To the director. Where is the 15th May letter?
Lordship, page number 31, Lordship.
To the Director, Panchayat and Rural Development, Government of West Bengal. By letter dated 27th December 2019, the Deputy Director, Panchayat and Rural Development, West Bengal, returned the proposal with a request to resubmit the same along with the documents, namely the revised 3 main inquiry committee report in original, semicolon, attested copy of PPO and proof of GISS receipt, and check memo. Number 3. Check memo should be signed and parity should be maintained regarding financial dues receipt as per 3 main inquiry committee report. On 34 is submitted on which date?
Which one, my lord?
On 17th May 2022, the petitioner submitted the application in proper format, which was forwarded to the concerned authority. By letter dated 16th December 2025, the prayer of the petitioner was rejected by the authority concerned on the ground of delay in submission of the prescribed format in Annexure A. Being aggrieved by and dissatisfied with the action of the authority concerned, the petitioner has preferred the present writ petition challenging the impugned order. Mr. So-and-so, learned advocate for the petitioner, submits that the application of the petitioner was, the petitioner submitted his application seeking for compassionate appointment to compassionate ground within 2 months of the death of his father. The subsequent thereto, the petitioner submitted ওটা করুন ওই সাবমিটেড যেটা করলেন না ফার্স্টটা in plain paper. Subsequent thereto, petitioner has submitted his application in proper format on 19th May
17th of May
17th May
2022.
2022. The prayer of the petitioner seeking appointment on compassionate ground was rejected on the ground that the format has been submitted after 5 years and 7 months. However, the authority concerned failed to take into consideration that the application seeking for appointment compassionate ground was submitted by the petitioner within 2 months.
6 months possibly, my lord. 5th of January 2017, the application was filed and the
No, 2 months was
petitioner's
the date
father,
of death.
October 2016, the father of the petitioner died. And
October, November, December, 2 months, and January, yes,
January,
right.
January, that way, huh? Sorry, my lord, my mistake.
Within a period of 3 months, because 3 months, more than 2 months. 3 months goes within a period of 3 months. Therefore, the findings made in the aforesaid letter is not sustainable. To buttress his contention, he relies on the decision of this court passed in Niloy Kumar Samanto versus State of West Bengal, WPA 21229 of 2023, and Binoy Sardar versus State of West Bengal and others, WPA 20858 of 2024. On the contrary, Mr. Kunaljit Bhattacharjee, learned advocate appearing, learned additional government leader appearing for the state respondents, submits that as per clause 10A of the notification number 251-EMP dated 3rd December 2013, the application for employment seeking employment on the ground of application for appointment on compassionate ground is to be submitted within 2 years from date of death or retirement. 2 years from the date of death or retirement on permanent incapacitation. Clause 10B requires that such application is to be submitted in prescribed format as provided in Annexure A and B. The records clearly reveal that such application in prescribed format has been submitted by the petitioner after expiry of 5 years, that is on 17th May 2022. On such ground, the authority concerned has rejected the prayer of the petitioner seeking appointment on compassionate ground, and therefore it does not call for interference. Upon hearing the learned advocates for respective parties, the only issue which falls for consideration is whether the impugn letter dated 16 December 2025 reject of the concerned of the Assistant Secretary to the Government of West Bengal, respond number 2, is sustainable or not. It is not in dispute that upon demise of his father on 6th October 2016, the petitioner made an application, submitted an application before the Block Development Officer Tufanganj seeking for his appointment on compassionate ground on 5th January 2017. The application in prescribed format has been submitted on 17th May 2022. Although it has been strenuously argued that the application in prescribed format ought to have been submitted within a period of 2 years. However, one cannot be oblivious to the fact that the application in plain paper was submitted within a period of 2 years, that is on 5th January 2017. There is also no iota of record that upon such application being made by the petitioner in plain paper, the authority concerned intimated him to submit the application in proper format. Para. In considering an application for appointment on compassionate ground, what is important is the substance and not the form. The scheme is meant to be a beneficial scheme aimed at helping those who need assistance due to untimely death of the employee. The court করবেন Supreme Court decision. এখানে para 8 নিলয় সামন্ত. Bearing in mind this scheme para being a beneficial one and the observation of the Honorable Supreme Court as above, the rejection of the application of the petitioner seeking compassionate ground on compassionate ground by respondent number 2 is not sustainable in law. Accordingly, the same is set aside. Accordingly, later dated such and such 16th December 2025 is set aside. Who will consider?
My lord, this final has to be considered. Deputy Director, possibly, my lord, 7.
Special Secretary.
Special Secretary.
Special Secretary.
This order was passed by the Assistant Secretary. My lord will kindly direct the respondent number 2 to again consider. To pass the order in accordance.
Set aside. Accordingly, respond number 2, Assistant Secretary.
2 and 3, Lordship. Kindly.
Panchayat and Rural Development is directed to reconsider the application of the petitioner seeking appointment on compassionate ground in accordance with law within a period of 4 weeks from date of communication of this order.
Lordship.
Report.
Are we 2 p.m. fixed?
68.
Item number 68, I am appealing for the petition. This matter was heard by your lordship regarding the issuance of the license in favor of the private respondent whose near relative has already the fair price shop license, lordship.
Led by Mr. Jalpaiguri, Mr. Jalpaiguri, lordship, please in before the court number 7, lordship. He's paying for 1 day's accommodation, Lordship.
Malad, may I submit one thing, Malad? If it
who
is
is
not taken up today, kindly, my learned friend may kindly make sure that it will be taken up tomorrow, Malad. I came from principal bench, Malad. I will be till tomorrow. I am here, Malad.
Yes, Lordship.
Ask him to come.
Lordship, he's.
My lord, your lordship has already heard this matter.
Well, I have
Well,
some
online.
submissions to make, Malad,
Yes,
but the submission of the state is also vital. There are contradictory
Yes, Lordship.
statements made by the
And
state.
report he has kept Lordship, so Lordship.
Who?
At least 1 day's Lordship accommodation
Who
is
is?
paid. Mr. Jagrati Mishra.
Ask him to come. Let him continue. You are for respond number 7.
I am for the response.
Make
He
his
has
submission.
back-to-back matter before the division bench, Lordship, today. He's just paying for
Division-
1 day's accommodation, Lordship.
Division bench is not there.
Can you place
Division
it
bench
before the
is
next
over
circuit?
there. Division
It will
bench
then go
is.
to the next circuit bench.
Hey, huh?
There is a heavier corpus fixed matter, Lordship. He's doing the
Till
matter, Lordship.
2:30.
Then Lordship, then fix it, 3.
Today is again 3:30. Ask him to come. How long?
It is 3:30,
Then Lordship, tomorrow, first matter, Lordship.
Late, my
But tomorrow I
learned.
have no objection, my lord. I am,
Time, Lordship, if your Lordship allow and pick it tomorrow, Lordship, 10:30, please.
Oh, lordship, kindly allow the learned advocate
No, no,
of
Allah
the
will-
private respondent to submit, and I'll submit. In the meantime, my lord, the state will appear. That's it.
You make your submissions. Let Mr. Mishra come. If he comes within the time, he will make his submission. Tomorrow I'll take his submission.
আমাদেরকে সাবমিশন করতে বললো আপনার কাউন্সিল এই বিষয়ে আপনাদের কিছু বলার আপনি করতে বলুন।
Lordship, what can I say? But I'm instructed to take time, Lordship. If your Lordship allow, then it will be great help, Lordship. For him, because he's engaged for some criminal matters there.
Told you that I have fixed it at 2 p.m.
Tomorrow.
But that's why I came from my principal bench.
Sir, let me allow to recollect within 5 minutes, my lord.
No, I have.
The learned my lord, advocate for the private respondent can submit, lordship.
Mr. Miss Singh, you
Ma'am,
take
can you
down
take
the
it up
note.
tomorrow at 2 p.m. First matter, madam. Let it be. Make sure
Take.
সে কোর্ট বলবে আমি কি বলবো the business of the court. Lordship, kindly take it up tomorrow at any time, madam. Till tomorrow I am here.
Tomorrow I have fixed GTA matters,
That's the difficulty.
which will continue. I don't know how long.
Yes, that's the difficulty now.
Mr. Mishra is also appearing in this.
Yes, Lordship.
Then
My lord, it is
then it
stuck
goes
in
to
a.
the other on 17th. Tomorrow is 17th. Then
Tomorrow
on
is
18th
17th.
there are GST motions.
Yes, your lordship, kindly take it up, lordship. Lordship already heard this matter. My lord, it will
Or
take
else
not
I
more than
place it
5 or 6
before the next
minutes.
circuit bench. It goes to-
No, lordship, kindly consider. No, my lord, private respondent will say always as your lordship pleases, my lord. My lord, I have strong objection, lordship. Your lordship has heard it, your lordship knows the matter very well, lordship, kindly, my lord.
3 days.
My
What
lord, only
to
that
do?
is why, lordship, kindly take this up matter. My lord, since your lordship has fixed this matter. But this is also a court, lordship.
Who denies it?
No, lordship, because your lordship has already fixed. My lord, I am suffering, lordship.
Mr. Chakraborty, you start. Miss Singh, you
Lordship,
take
I am
note of it
informing you, Lordship.
so that we can take it up. If Mr. Mishra does not come within this period of 3:30, within this period, then we can fix a date for him to make his submissions tomorrow.
Lordship.
That will be, yes.
Boleh, sir. Yes, sir, but allow, sir.
Lordship, my submission is, my lord. What is the status of a
Here.
what is the status of a married woman in a Hindu society? My lord, here the fact is that the respondent number 7, sister Komita Bormon, married to Bivas Chandra Bormon, who is a dealership, who is having a dealership. And there is a bar in the clause that if anyone is having a dealership, they should not apply or they should not be considered. But my lord may now kindly consider one reported judgment of this Honorable High Court.
No, first, show me the definition under 2XA.
Lordship may kindly 2x, the definition is right here, my lord. 2x 3/4 স্যার এটা
আচ্ছা অর্ডারের মধ্যে লেখা আছে
অর্ডার করতে হবে
টাকাটা কবে
Son's son, sister, her spouse, son or daughter, brother, his spouse, son or daughter. You are four.
Fourth, my lord, it comes under four.
Four.
Now, Lordship may kindly consider one judgment of this Honorable High Court, which is reported in 2009, Volume 1, CLJ Calcutta, page 650, 615.
Volume?
1. My lord, here is the book, my lord. Lordship may kindly consider.
614.
6.
So 614.
My lord, here, my lord, it has been disputed what is the status of a married woman. The fact of the case is, the Moshumi Das Maiti, she participated in the selection process of auxiliary nurse cum midwife. And she was married, and the clause was that the candidate should be in the residence where the advertisement was done. This was the fact of the case. Now, Lordship may kindly have a look to the order which runs from page 617.
Here.
May I read it, my lord? Paragraph 2. Challenging the judgment and the order dated 31st July 2007 passed in WP number so and this appeal has been preferred by writ petitioner oblique appellant whereby and where under the London trial judge rejected the writ application challenging the selection of a candidate for the post of auxiliary nurse cum midwife. Now, my lord, paragraph 3, the writ petition was moved by an unsuccessful candidate assailing such selection on the ground that the selectee did not qualify eligibility criteria of permanent residency of the area where the health sub-center was located. In the writ application, it was the case of the writ petitioner for a vacancy of the said post in Gangarampur sub-center, the selectee claiming her permanent resident at village so-and-so. The marriage held on 19th October 2006 and she applied thereafter for the post on 24th November 2006, disclosing her permanent residency as husband's house. In the appeal, it was contended before us that the appellant oblique writ petitioner, though she is a housewife, she is a resident of her matrimonial home for at least 10 years, which is within the area jurisdiction of the concerned post. As such, she was eligible to be appointed in view of the special fact that the advertisement permanent residency in the locality was fixed as eligibility criteria. Now, Lordship, the learned trial judge dismissed the writ application on the ground that as per Hindu customs prevailing in the society after marriage, the wife's permanent residence changes from parental house to matrimonial house. The impugned judgment of the learned trial judge read as such. Now, my lord, I am skipping the judgment portion. Now, Lordship may kindly come to paragraph 5.
Yes.
Having regard to the rival contention of the parties, the only question involves hearing for our decision as to whether on 19th October 2006, after completion of the marriage, the selectee became a permanent resident of the area wherein her matrimonial house is situated. The learned trial judge answered the point by mentioning only the Hindu customs to identify the residency issue. In the writ petition, there is No allegations such and such, my lord. Now lordship may kindly skip this portion and kindly come to twentieth line, my lord, from the top. The sentence starts with to identify the question. May I read it? To identify the question, we made a search through customs rights prevailing in the Hindu society, an age-old civilization, by considering the religious script on that issue. It appears that Hatara, an intellectual and literate personality who was well versed with the Indian culture in his test, has contended that as soon as a girl is offered to the husband, she becomes equal to her spouse in point of status and membership of the clan of her spouse, and at that material moment the girl loses the membership of the clan of her parent and consequently her title also. In view of Hatara, was quoted in a book titled as Uttavata by Raghunandan, a book compiled. It is Sanskrit. A book compiling customs rights prevailing at the material time. As for the saying, it reads such. My lord, this is, I'm sorry, my lord, this is written in Sanskrit, my lord. I'm escaping it, my lord. Lordship may kindly come to the translated portion. I'm very sorry, my lord.
Yes,
Six, the English translation reads as such. The girl due to her marriage, as soon as she moves 7 steps, she loses the membership of her clan and consequently the title of her parent. Religious right on such girl after her demise and also during her lifetime should be performed, quoting membership of the clan to which her husband belongs. That is the gotra of the husband. In view, paragraph 7, in view of the Hatara was quoted by Raghunandan, a scholar, as already referred to in the book the Brahspati also, the author said, the girl loses the membership of the clan to which her parents belong as soon as her marriage is solemnized with the husband. Having regard to the aforesaid views of different authors, the Hatara, the Raghunandan, and the Brahspati, it is clear that as soon as the girl completed 7 steps movement after marriage with the husband, which is also a ritual required to be performed in Hindu marriage, immediately from the moment she loses identity as she was existing in pre-marriage stage with her father, family includes the residence and the gotra, that is the clan, and she becomes a part and parcel of the gotra, that is the clan of the husband's family, and her identity is permanently attached with the husband clan and the family, and permanently residence also is changed from parental house to matrimonial house. Considering the authentic text as referred to, we are of the view that on 19th October 2006, just after marriage, a selectee lost her membership of her clan, that is gotra of her parents, and she became the member of the clan of her husband, including the gotra and residence. Even in matrimonial law, there is a provision for right of residence, roof under the canopy of maintenance, in the event there is a separation from the husband by the wife. My lord, the fact is, my lord, here,
yes,
here, my lord, in the present case, my lord, the sister's husband, respondent number 7, sister husband is having a top. That's why in the rule it says sister, spouse, son, daughter. If family means this. Now, my lord, if the sister of respondent number 7 is married, she is no more in the family. My respectful submission is the rule which I have handed over to your lordship is not happily drafted. If a daughter gets married, she goes out of the family and she becomes the permanent family of the husband. Now, my lord, this rule is not happily drafted, my lord. This is my one of my submission, and
Yes.
And my lord, another thing, my lord, so far as the previous writ petition is concerned, which was pursuant to which an order was passed, a hearing was conducted. The previous writ petition was WP number 2884 of 2022.
Page 59.
Page 59, order is of 30th November 2022. This Honorable High Court's order, which says the same allegation was taken, and if Lordship may kindly come to the page 61, first, second, third, fourth paragraph. Upon hearing the parties, page 61.
Yes.
Upon hearing the parties and upon perusing the documents, as also the records maintained in the office of the Subdivisional Controller, Food and Supplies, Matabanga, a reasoned order shall be passed and communicated to all concerned. This was a clear direction given by this Honorable High Court to the Subdivisional Controller, Food and Supplies. Now, after this order, my lord, kindly come to page 63. The note sheet of the department. Hearing on order of Honorable High Court at Calcutta, Circuit Bench at Jalpaiguri, WP number 2884 of 2022. This was the hearing, the proceedings drawn by the department. Then Lordship may kindly come to page 65.
Yes.
Second hearing was done. Second hearing, order of the Honorable High Court at Calcutta, Circuit Bench at Jalpaiguri with regard to same writ WP number. Now, my lord, the inquiry report which is at page 66.
What does it say?
It says, my lord, kindly come to page 68. Second last paragraph. Page 68, second last paragraph. Both Bhavesh Chandra Pormon, Emma Dealer at so-and-so, under Gram Panchayat so-and-so, block 2, and his wife, Kobita Pormon, have denied that there is no relationship with Emma Vishnupada Adhikari and they are not their relatives. This is signed on 27th April 2023 by the Subdivisional Controller, Food and Supplies, Matabanga. This is the report which was filed after conducting hearing pursuant to the order of the Honorable High Court. Now, my lord, there is another report which was filed, which was handed over to me on the last occasion, my lord. Which and the report which was filed on 15th December 2023. Which report had to be taken into consideration, my lord? This is the point where the state should come and clear it, my lord. And my lord may kindly consider page 2 of the report which was filed.
How the earlier inquiry report, which has been taken into consideration pursuant to order passed in the earlier writ petition.
My lord.
How it says that the Vishnupada Adhikari, Kobita Adhikari or Kobita Burman is not the sister of Vishnupada Adhikari. By
But-
what materials it comes to this finding?
Well, that the state should reply. It's
No,
not
no.
my report.
This is the inquiry report which has been based. The order has been challenged, which has been passed basing on the earlier inquiry.
Earlier report. The present writ petition is
So
challenging
since
the order of
order is over here, on the basis of which document or which evidence it has come to this conclusion that both this Vishnupada and Kavita are not the brother and sister.
Now, Lordship, kindly allow me to place the entire
Lordship,
inquiry report.
paragraph number 4 of the report, Lordship, where the ration card has been annexed, Lordship.
ওইটা বলছেন না earlier report
Earlier, देखिए,
Your lordship, inquiry report, page 68, your lordship. The last three para, your lordship.
My lord, earlier
The
report
respondent
is
has submit a executed before first class magistrate Mathabanga legal hair certificate issued by the Gram Panchayat Pradhan of Salishwari GP.
On the basis of statements and affidavits filed by Vishnupada.
Yes, your lord, that is what, my lord, I have submitted earlier occasion, this report only on the basis of the some questions asked to Vishnupada and whatever the Vishnupada said on the basis of that inquiry report. Now, if your lordship kindly see the earlier order, my lord directed to the respondent to consider and dispose of the petitions, my lord, taking into considerations of the record maintained in the office of the subdivisional controller, page 61, lordship. Page 61. What my learned senior friend.
Mr. Chakraborty, you conclude your argument. Come back to you. You
My lord,
indicate.
so far as the new report which I have received,
Yes.
which is dated paragraph 3, Lordship may kindly consider, which was affirmed on
new कौन सा है?
15th December 2023. Paragraph 3 kindly consider. It is the report of the state.
Yes.
Paragraph 3 says, as per the record, office record, there is no relationship between Kavita Bodmon and the private respondent number 7, that is Vishnupada Adhikari. It is their report.
But lordship, kindly see the paragraph number 6, lordship.
Report and yes.
My lord, my submission and my conclusion is this, my lord, after marriage, she is no more with the family. She belongs to a different family. And the rule which has been handed over and stated that spouse, daughter, this is not a correct or it is not happily drafted, my lord. This is my respective submission.
May I submit, lordship?
No.
Yes, lordship, lordship, because I am led by Mr. Jagiti Mishra, lordship, I am praying that he would submit, lordship, tomorrow, lordship.
Okay.
My lord, may I submit, lordship?
But
Then
because the report is itself confusing, in one paragraph, the state is
You
saying
just
that
find
there
out
is no
whether
relation,
Mr.
lordship.
Mishra is-
Yes, lordship.
Whether Mr. Mishra is coming or not. We have time.
Thanks, lordship. Actually, lordship, this matter was allotted yesterday to him, lordship. For this clarification, we need at least 1 day time because the report itself is a contrary. In first paragraph, the state is saying that there is no relation, but in this paragraph number 6, pursuant to the RTI filed by the petitioner, lordship, there is a reflection of the relationship, lordship. So we need at least 1 day's time to clarify this portion, lordship. Paragraph 3 speaks different and or 3 and 6 is contradictory to each other, lordship. It is also. But this is not replied by us.
By mistake.
not by mistake, by pressure.
কে ফাইল করছে?
যাই হোক তুমি এখন জানোই দাঁড়া আগে কি ছিল না ছিল সেটা আপনাদের ডিপার্টমেন্ট
For that I need 1 day time.
ঠিক আছে নাও আমি প্রপোজ করছি
See, P is a statement which has got no basis.
Yes,
It's
Lord.
just a statement stating that they are not related. But the statement in 6, he says that he has, after the RTI application being filed by the petitioner, he has checked of the records.
Yes, Lordship.
Subsequently, he
Yes,
says so.
Lordship. Yes, true, Lordship.
And there he finds that these two are the daughters of some.
Girishankar Adhikari.
Girishankar
Now,
Adhikari, the
if
son
we
and
come
daughter.
to the document that has been annexed as 14/12/2023. This is the office records of the subdivisional controller F&A, which also say Vishnu Pado, son of Girishankar.
And Lordship, it is also stated that I stated that there has been relationship between Vishnu Pada Adhikari and Kobita Bormon as per office record.
This is contrary to paragraph 3.
That is a statement, and this is the document.
And it has been verified as true and personal, to my knowledge. Kindly see the paragraph 7 of the page 4, paragraph 7. 1 to 6 are true to my personal knowledge.
Dispose it of that.
Yes, Lordship.
We'll dispose the petition.
Or Lordship, only 1 day's accommodation, because Lordship, the report itself speaks two different kind of opinion, Lordship.
Okay. Heard Mr.
My lord,
Himadri
my lord,
Shekhar
one submission, my lord, one
Chakraborty, learned
submission.
learned advocate for respondent number 7. Yes, Ms. Mona.
My lord, Lordship is disposing this matter today only.
We want to make their
My lord,
submission.
yes,
and
my
clarify
lord,
this issue.
the only one thing, my lord, the judgment which has been placed by my lord.
Madam, you'll
Tomorrow,
get your
tomorrow.
After
Tomorrow.
he concludes, you make
Tomorrow.
your reply thereafter.
Tomorrow.
Even Lordship, just 2 minutes ago, before the hearing, I got the brief, Lordship. I'm not aware of the fact, Lordship.
Ask Mr. Misra to conclude
Yes,
his
Lordship.
argument tomorrow so that.
Yes, Lordship.
Timurun? Advocate for respondent number 7 who concludes his argument. Ms. Supriya Singh, learned advocate for state respondent seeks accommodation on behalf of Mr. Jagriti Misra, learned assistant additional advocate general. Madam, you produce the
Yes, Lordship.
Part 3, Clause 13(1) of the notification dated 2nd December 2021. It has been annexed but not legible.
Not legible.
Let's produce a
Legible.
legible copy of that.
Lordship, part 3.
Part
My
3,
lord, may
clause.
I type it, my lordship, because this is what I have got,
This,
lordship.
Mr. Chakraborty, it is not over here.
No, no, no. It is not over. That is the rule. And it is advertised.
Part 3, my lord, may I type it, lordship?
Okay, you can do it. Place it tomorrow.
My lord, a time maybe, my lord, fixed, lordship, a time.
Yes.
Yes, 2 p.m., Lordship, 2 p.m.
আমার 5টায় ট্রেন আছে যেতে পারবো
হ্যাঁ
এটাতে দিয়ে দাও
আরো বলবেন আপনি
আমি কেন বলবো
2 PM করে দাও, কালকে শেষ হয়ে যাবে। কালকে যদি জিটিএ হয় তারপরে এরকম শেষের বেলায় দেখবো কি হয়।
আমি
আমি পেছনে বসে থাকবো এই সামনে বসে
Please, this matter tomorrow 2 PM.
2 p.m. lord. I'm extremely
grateful, my lord. My lord, may I take back the book and give a Xerox copy of the judgment?
এটা দিয়ে দিন তাহলে।
My lord, only part 3, my lord, I am typing, lordship. The
Part 3 will do that portion, part
Yes,
13(1).
Part
That the family, if he once comes under family, he cannot be
his
granted.
relative will not be entitled, lordship.
বানানটা ভুল দিয়েছো আমি জানি আমার বানান
What is the complete name of that rule? It is
The rules, lordship.
rule, yes. West Bengal,
ফাইলে রেখে দেবেন এই দুটো আমাকে দিন
West Bengal public distribution. What is that?
This is the
West Bengal public distribution system bracket control and maintenance and control bracket close order 2030.
হ্যাঁ এইটা একটা ছবি তুলেন হ্যাঁ
Next.
আরে এখানে লেখাই তো আছে
28 দেখে পড়ো
এরকম সেরা আমি
Highways Act. My lord, I am for the state respondent.
None appears on behalf of the petitioner.
This is this case, my lord, where the inquiry was conducted by the authorities under the West Bengal State Highways Act, whether the petitioner's shop is encroaching into the PWD land or not. Yesterday, my lord, report was ready. That come with a supplementary affidavit.
The
Now,
final order has been passed. He
yes,
challenges the
no, not an
notices.
order, a report, inquiry report has been prepared that half of the a part of the shop is encroaching. So yesterday, my lord, Mr. Devasridhar had asked for a time to take instruction whether his client is agreeable to demolish that part or not, and he has to come with an.
28. Is the appealing advocate for the private respondent, my lord. His legs are before court room number 4. Kindly, my lord, make it short. Pass over, my lord.
Tomorrow, not today.
Tomorrow.
Not today.
Not.
Mr. Dhar is here.
Yes. What is your instruction? No. Didn't.
May I find the report? Report.
My supplementary.
A copy দিয়ে দিয়েছি কালকে তোমাকে।
Supplementary.
তুমি কপি দাও নি।
Hey, all the towers.
Yes, my lord.
Your lordship, text of my supplementary affidavit, lordship. These notices have been issued in the name of Jahanara Neha and Namir. Now, lordship, these entire proceedings, they have been started pursuant to the order of the Honorable High Court, asking this. The 2363 of 2025. The lordship will find it at page 41 of the writ petition.
Yes.
Even lordship takes that order. In this writ petition 2363, lordship, neither Namiruddin nor Jahanara Begum was a party. So how can these proceedings be maintained? Even lordship sees the cost title of this writ petition. This lordship finds page number 44. The relevant portion is page number 46. It is in the name of Nizamuddin. When I brought all this fact that I am not Nizamuddin, I am Namiruddin, and my wife Jahanara, she was never a party to the writ. How can you serve notices? When I brought everything before them, they midway changed the earlier notices were sent in the name of Nizamuddin. Now they changed the course, sending notices in the name of Namiruddin. My first was, can they? They are acting on the basis of an order. The order says, act in the take steps in with respect to the respondent number 6. I am not respondent number 6. Are the notices maintainable against me?
Very much maintainable. It is not against a person, but on the encroachment.
Lordship.
The order is passed to that effect, that any unauthorized construction is found shall be removed in strict accordance with law. If you say that,
Any encroachment is found.
if you are not, if you have not encroached, then you have no grievance. Because you are not encroached. Let them act in accordance with law. If they find any encroachment, they will remove that.
Much obliged.
Now,
If you say so, the order is a order which says that if in certain plot of land, there is any such of unauthorized, that should be removed. This order stands as on date. After you have found out from the authority that there is an order passed in a writ petition where Nijamuddin was a party, not Namiruddin, you did not approach the court to file an application seeking for further clarification or review of that order. That you have not been made a party, nor your wife has not been made a party. This order stands. On the basis of this order, they have approached. Once that order is not set as it, which says that you remove all the unauthorized construction, there cannot be any writ petition maintainable at your instance. They will, if you have, what is the notice given?
My lord, if you kindly see, takes up my report at page 4.
Page 4.
Page 4 of my report. My lord is there.
Yeah.
It is dated 28th of April 2026. Addressee number 2 is the petitioner, Mohammad Namiruddin.
Namirud.
Yes. Now, this is, my lord, there's a notice whereby, my lord, the addressees, among them, my lord, the petitioner and his wife, were called on 5th of May 2026 at 3 p.m. Second paragraph, my lord, in the body. In the office of the undersigned, my lord, who is the assistant engineer PWD, with the following documents and original with one self-attested photo in support of your claim. These are the documents, my lord. They chose not to come. Then, my lord, kindly takes up page 6 of my report.
This is the initial notice.
Which one, my lord? Yes, addressed to Namiruddin, this as per my instruction.
But can they show that this notice was served upon me? My notice, Lordship, kindly takes page.
Then, my lord, at page
49 of my petition, first notice, that was
Yes.
29th April.
Wait, Mr. Dhar, wait.
Lordship.
Then, my lord, at page 6.
Yes.
This is, my lord, dated 2nd of June 2026. Here, my lord, the inspection was done, and in the inspection, my lord, it was found that a portion of the shop of the petitioner is encroaching in the PWD land, my lord. Along with this, my lord, the sketch map and all inquiry report have been annexed, and the petitioner, my lord, have been asked to remove it within 7 days, or else, my lord, the necessary steps under section 10 of the West Bengal Highways Act will be taken. Now, my lord, kindly sees the peon book. Peon book, my lord, appears at page 14. Now, peon book this one is dated, page 4 is 372. Right. 372, my lord, will appear. What does she logo? Yes. The page 18, my lord. Kindly comes page 18.
Yes.
Where it chooses not to sign, my lord.
Okay.
But having said that, my lord, even for the sake of argument, but not admitting that this was not served upon them. Today, my lord, it is in their knowledge. Admitted position, my lord, there is an encroachment.
Yes.
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 Page 21. Yes, I'm sorry, my lord. Kindly comes to page 21. I'm sorry.
Yes.
This one, my lord, at page 21, to Mohammad Namiruddin, my lord. On 2nd of June, this was received, my lord. Kindly sees extreme right, signed in Bengali. And the third column from the left, my lord, is the memo number of 477, which my lord will find at page 6 of the report. Page 6 of my report, my lord, memo number 477.
Yes.
Great. So, my lord, even then, my lord, notice is there, he has to remove it, or else, my lord, we will be taking steps in accordance with section 10. Section 10, my lord, stipulates, may I hand over, I just print out ID, the act. Sorry, my lord, I'm traveling once, your lordship, with the tab once with the these printouts.
What to do? Books are not here.
Sir?
Books are not here.
All books are not here. My lord, section 10, my lord, I am relying. Section 10, if any person is found to have made an encroachment on any road, street, path, way or land which is declared to be a highway under subsection 1 of section 3, or makes an encroachment on a highway in contravention with the provisions of section 8, or does not remove an encroachment on the expiry of cancellation of any permit granted to him, the highway authority or any officer authorized by him in this behalf shall serve a notice on him requesting him to remove the encroachment and restore the highway to its original condition within a period specified in the notice. Pausing here, my lord, the notice dated 2nd of June, my lord, is the notice now under section 10(1), this provision, my lord. Now, subsection 2. If the encroachment is not removed within the time specified in the notice, the highway authority or the officer authorized under subsection 1 may make an application to an executive magistrate having jurisdiction over the area, not being the district magistrate, for removal of the encroachment and delivery of possession of the land encroached upon the highway authority or such officer. Next, such magistrate may, on receiving the application and after notice to the person responsible for the encroachment and taking such evidence, if any as he thinks fit, may take an order authorizing the authority or officer to recover possession and remove the encroachment in question, and may, if necessary, direct the police to assist in the enforcement of the order. Next, my lord, 4. If the person responsible for the encroachment is aggrieved by an order of the magistrate made under subsection 3, may within 15 days from the date of the magistrate order appeal to the district magistrate. The district magistrate shall, after hearing the parties, make an order affirming, modifying, or setting aside the order made under subsection 3. So here, my lord, after this notice, my lord, we will be approaching the executive magistrate. The executive magistrate will issue notice. My lord, the petitioner has his chance to agitate his points before the executive magistrate. If the executive magistrate passes an order against the petitioner, he again has a chance to approach the district magistrate, my lord. So this, my lord, in my respective submission, is not the end, but this is a part of the process which has been initiated. So remedy is there with the petitioner, my lord, even after the notice of 2nd of June 2026. And another thing, my lord, the order of the High Court, which my learned friend is relying upon, what has fallen from your lordship, that lordship is not sitting in appeal, my lord, what I have gathered. And second, my lord, the order does not stops the authorities for taking action in accordance with law against any person who the authorities think has encroached illegally on the government land, my lord. So even if he was not a party to that writ petition, that does not, my lord, stops the authorities from proceeding in accordance with law against the petitioner, my lord.
If that is so, lordship, then there cannot be any pick and choose, lordship. There are other shops also.
That point cannot be agitated, my lord, by a person who is in unauthorized occupation. One wrong does not make another wrong right.
Lordship, I am not disputing the services of the notices dated 2nd June. I am not disputing the services of the notice. It was served upon me. But lordship, kindly see, these notices are issued on the basis of the order passed by the High Court, whereby I was not a party. So Lordship, in case Lordship directs the proceedings to continue, I will be praying before your Lordship to direct the concerned authorities to direct them to serve notices afresh, allow me an opportunity of hearing inquiry in my presence, and I'll be able to.
2nd June notice has been served upon
Yes,
you.
my lord, that has been received by him.
But the 2nd June notice.
And he has his my lord, remedy before the executive magistrate. These are factual aspects, my lord, which the writ court in my respectful submission, my lord, cannot go into.
This notice dated 2nd June, Lordship, it says that.
And his wife has received the earlier notice, my lord.
He has appeared also.
Today, my lord, the petitioner is admitting that Jahanara Khatun is the wife, whereas my lord, in one of the affidavits which is part of the writ petition,
At page number 47.
47, my lord, she says that she is the daughter of such and such, instead of saying the wife of such and such. Then, my lord, it would have been very evident that knowledge of this notice was with the petitioner, my lord.
Moreover, the advocate was same. Moreover, the advocate
Before
was
Lordship takes the 2nd June notice, Lordship, the second page, the time was given, 7 days time was given. But now 7 days period has already been over. Now they will be posting to the STO. I will be visiting your Lordship to direct them to again reissue this notice, allow me a fresh opportunity of hearing, allow me to place before the relevant concerned authority all relevant documents I have, thereafter an inquiry, and pass our order.
My lord, this cannot happen at the, my lord, choice and option of a encroacher, my lord. First, the encroacher will either refuse to accept the notice or will, my lord, say that notices have not been served when everything is before the honorable
Heaven will
court.
not fall upon them if they issues if they allows me a fresh opportunity of hearing.
The petitioner has his chance, my lord, under section 10 before the executive.
But time period is already over.
No, that time period, my lord, can always extend.
Yes, that will I am praying.
Before the executive magistrate.
No, this order was passed by the executive. Before Lordship direct, this notice was issued by the assistant engineer.
Yes. So under
He
10.
sends me back to the assistant engineer.
No, my lord, that I am objecting, my lord. Under 10-2, now, my lord, before the executive magistrate.
10-1.
10-2, my lord. 10-1 is complied with now. 10-2, my lord. If the encroachment is not removed within the time specified in the notice, they have authority, or the officer authorized under subsection 1 may make an application to the executive magistrate having jurisdiction over the area, not being the district magistrate, for removal. So here, my lord, I will now, my lord, approach the executive magistrate. The executive magistrate will issue notices. Then the petitioner has all the options to educate all the points.
10-1 is if it is found to have, it is determination. They have already determined.
It is a preliminary determination, my lord.
Come to 10-3. 10-3.
10-3. Such magistrate may, on receiving the application after taking notice to after notice to the person responsible for the encroachment, and on taking such evidence, if he thinks, if any, as he thinks fit, make an order authorizing the, yes, my lord. So that is what I have been submitting, my lord.
But 10-3 will section 10-3 empower the magistrate, the concerned magistrate to direct for a fresh inquiry?
Yes, he can, my lord, even if the evidence
It
is.
goes on to say, if any, as he thinks fit.
Yes.
Make an
Such
order
magistrate on
authorizing
receiving
authority
application
or
and after
officer to
notice of
recover
a
poison, remove
responsible
encroachment.
and on taking such evidence, that evidence is already before him. I want the fresh evidence to be watched. I want a fresh inquiry.
What the petitioner
If you
wants,
don't
my lord,
respond
cannot
to
be
the notice
the
sent.
harm rule.
No.
No, if you don't respond to the
It's not a
notices
case
sent.
that I have not responded to the notices. It is that I have challenged those notices before the Honorable High Court.
Once, my lord, he says he has not received. Now the
I
petitioner
have
says
never-
that he is challenging those notices.
I have never disputing that receipt of the notices.
He has been, my lord, till now he has
already
been.
saying that those notices are not issued in the notices in the name of Nazimuddin.
Asuna.
I am only playing lordship.
By the
Direct
present-
the concerned authorities to grant me a fresh opportunity.
Supplementary affidavit filed on behalf of the petitioners is taken on record. A report filed by the
Report has been filed by not
behalf of, filed by respondent number 5
five, my lord.
is also taken on record. By the present petition, the petitioner seeks for setting aside and or cancellation of notices dated 17th April 2026, 20th April 2026 and 29th April 2020 issued by the concerned authority. 17th April is where it is? Then 20th April. Where is the notice dated 20th April 20?
My lord, 20th April.
Yes, 20th April.
17, আর 19
Hello. This is second round of litigation. Binoy Agarwal is a party. Who is you are representing?
So I am representing private respondent 6, 7 and 8.
6, 7 and in the earlier round of litigation, being WP 2363 of 2025, the private respond numbers, all of them filed the writ petition.
Lordship, private respondent number 9 is dead.
So who filed the writ petition?
Writ petitions were filed by respondent number 6, 7, 8 and 2 other people.
6, 7,
Binoy,
8,
Suman and Savitri
8
Agarwal.
and 2 others.
Varun Agarwal and minor
Two
Maila
others.
Agarwal.
Okay, 2 others.
Lordship, 3 others, sorry.
3 others.
It is at page 44, my lord.
3 others. Which was disposed of with the following direction. Needless to mention. The petitioner challenges the notices on the ground that the same has been addressed to one Muhammad Nijamuddin and not to him.
My lord, may I kindly be excused, my lord?
To him. Mr. Deborshi Dhar, learned advocate for the petitioner, submits that his client, being Muhammad Namiruddin, has been forced to accept the notice in the name of Nijamuddin. His client Namiruddin and Jahanara is wife,
Wife.
and Jahanara Neha, his wife, is not a party in the earlier writ petition. He seeks that opportunity be given to the petitioner to take part in the hearing before the Assistant Engineer PWD Siliguri Construction Subdivision 2 Siliguri. Respond number
2 and 3. Two.
Respondent number, Lordship, assistant engineer is respondent number 5, executive engineer is respondent number 4.
This one of 5 is assistant engineer.
5 is assistant engineer.
Oh, 5.
It is found from the report that the report of the state respondents that notices were issued in the name of one Muhammad Nijamuddin, which was received by his wife on 17th April 2026, received by his wife. Who is this? Dohura. Jahanara. By his wife. Notice dated 17th April बोलो ना? Then 20th April. And 20th April 2026. Therefore, annexed to the report, report bolam na? Peon book ko peon book, copy of the peon book annexed to the writ petition. Therefore, the petitioner cannot agitate that he did not have any knowledge of such notice. It is pertinent to note that the subsequent notice dated 2nd June 2026 in the name of Muhammad Namiruddin has been received by the petitioner. Therefore, the contention of the petitioner that the notices were not served did not stand to reason. Therefore, the writ petition falls short of merit. Accordingly, the writ petition being WPA 749 of 2026 stands dismissed.
Much okay. When the paper is done, appear before the authority and allow me to place my documents.
Sir, notice under 10.2 has already been issued to you.
Yes, ma'am.
There is a provision under 10.3. No further clarification. No. You cannot extend the scope of the writ petition. If you challenge it that the notice are bad in law, I have explained what is bad and what is good. If you are aggrieved of that, after that 10.3 will apply for you. If you don't agree, then 10.3 will apply.
My lord, item number 33, my lord.